Hello, can everybody see me?
Yes, Judge.
Outstanding. That means that we are off to a semi-decent start of things working. Let me go in here and edit my timer. I just want to make sure everybody's on the same page. My understanding is 55 minutes. Do we have everybody here first, I guess? I should check that.
I don't believe I see our opposing counsel yet.
Well, then we probably shouldn't have these conversations. I seem to remember somewhere that that was not allowed.
Always better safe than sorry.
Stephen Lopez. Do we have a Stephen Lopez? We have a Stephen Lopez. Good to go. Timothy Goins. Did I pronounce that correctly? Awesome. Crystal Stapley. Cool. Is it Stapley or Stapley?
Stapley.
Stapley. Awesome. I apologize for my butchering of names.
No worries.
Kendall Gray. Good to go. Awesome. So we have our scoring judges. Let's see. Matthew Hobbs and Summer Combs. Okay,
Yes, they are the ones that are not here yet, I think.
Okay, and then, but Rebecca Nickel and Philip Meinkoff?
Yes, we are all accounted for.
Outstanding. All right, Jordan Gilmore and Reese Geller. I see we have one witness here.
We're here.
We're both here.
We're both here. Also, there's one witness computer. That makes a lot of sense. Awesome. So once our plaintiff's attorneys join us, we can get getting.
I think this is the first time in my Zoom mock trial career that the judges have beat us to the courtroom. So I'm very excited about that.
We do our best. I am going to change my chair though, because I'm not going to change my chair. I feel like you guys are seeing the top of my head.
Judge, do you remember what the protocol is? Are we to keep our cameras on or off during the round?
I believe the answer is off, and then when we come back, so we'll probably do like a mid-round break. That's pretty typical. I'll probably have you all pop back on so I can see that you're back, and I know that we can get rolling. But other than that, I think the camera's off the whole time for the scoring judges. Am I assuming that the jury charge? Oh, wait, here we go. We got our folks on here, I think. Mr. Hobbs and Miss Combs.
Yes, you.
Outstanding. All right, that means we have everybody. Unless somebody objects, I don't see any reason not to get rolling 5 minutes early. Anybody have a reason we shouldn't do that?
Nothing from the defense, Your Honor.
Nothing from the plaintiff, Your Honor.
Awesome. That means that I'll be the one who gets yelled at if I'm wrong, but I don't think there's an issue. I will need a pen.
Your Honor, just to make sure, do we have to wait for any kind of conflicts check or anything? I don't want us to run into that sort of issue.
But that was not told to conduct one, but I suppose if you would like one, why don't we go ahead and have the scoring judges pop on screen for one moment? And we will make sure. Do any of y'all know either myself, Mark Altman? You guys are supposed to have my wife. She's far nicer than I am. Sorry. Let's see. Myself, Mr. Stephen Lopez, Mr. Timothy Goins, Ms. Crystal Stapley, or Mr. Kendall Gray.
No conflicts on behalf of the defense, Your Honor.
Okay. Hearing no objections, we will get rolling. Thank you, judges, for popping your cameras on. All right, just a couple things. I've been told, I just want to make sure we're all on the same page. I've been told 55 minutes per side, not inclusive of objections. The one thing I wasn't told, hey, is the 55 minutes inclusive of pretrial?
No, that's 5 minutes, as you see on the sheet, 5 minutes for pretrial.
Oh, okay, there it is. Okay, great.
So 5 minutes for pretrial and then 55 minutes set.
Outstanding. Thanks, Robert. We're ready to get started. Pickle.
Good, you go.
Awesome.
Oh, I think for next time, at 10, there's supposed to be. Shouldn't be that bad.
Hey guys, so apparently at 10 o'clock there's supposed to be a tornado siren going off. My inclination would be to go and suck it up, but most of my experience has been doing this stuff with like F-18s and stuff going off around me, so I don't have much, worry about that. But if y'all would like to wait, we can wait till after the tornado siren.
Beauty of muting on Zoom, right?
Yeah, there you go. Yeah, you should always mute the judge. That's a good call. All right, so back to what I was saying. So my understanding is y'all get 5 minutes per side for pretrial, 55 minutes inside per side, non-inclusive of objections. I will be keeping that time. I can give you guys a time check at breaks. Just let me know if you want it. And then I have a pretrial order in front of me, but I've also been told to strictly enforce time. So I will be doing that. So if you'll hit your time limit, I don't care if you're in the middle of whatever, I will shut you down. Okay. Just want to give you a heads up about that in advance. Any questions about that? Outstanding. In that case, we're going to go ahead and call Gilmore v. Chimes Department Store, and we will get rolling. Is there anything pretrial for the sides?
Yes, Your Honor. The plaintiff does have one substantive pretrial motion we would like to address before the court.
Okay, real quick, is the defense going to have any kind of pretrial motion?
We do have some motions. I also have just two brief housekeeping matters if the court would like to entertain those first.
Okay, we will handle that. We're going to do substantive motions first, and then we will roll into housekeeping stuff. So plaintiff, why don't we go ahead and start with your substantive motion?
Yes, Your Honor. By way of brief background, today's case is concerning a premises liability issue of the defendant's store here in the town of Waco, Chimes Department Store, Your Honor. We believe the evidence today will show that the defendant had several different dangerous conditions on their premises. They had a dark, unlit stairway and an unrailed platform out in the back of their business that they asked their employees to interact with and work around on a regular basis. That brings me to my client today, Your Honor, Jordan Gilmore. He was one of the employees of the defendant in today's case, who was asked to go into that dark, unlit and unrailed stairwell to perform various duties that he was asked to perform as a part of his job. Which brings me to my first motion today, Your Honor. We anticipate that the defense will bring up evidence, as it was asked during the deposition, about whether Jordan had any complaints or ever filed any complaints about the railing or the unlit stairwell in today's case, Your Honor. We believe that under Rule 403, that evidence would be substantially more any probative value that evidence have, which, Your Honor, I contend there's zero probative value in whether my client asked about the stairwell or anything like that, Your Honor. Any probative value that have would be substantially outweighed by the danger of confusing the issues and misleading the jury, Your Honor. The OSHA regulations in today's case, as well as the International Building Code, do not apply to my client, and because of that, we would move to exclude any mention of that evidence today.
Response?
Yes, Your Honor, I apologize. Opposing counsel did not wish to discuss the specifics of this motion during our conferral before this. We don't intend to elicit any of that testimony, so we would stipulate that it will not be admitted in today's trial.
So are you agreeing to the motion, or are you just gonna tell me now you're not offering it?
Your Honor, we're not offering it.
Contest, okay. In that case, I guess the motion to limit is granted. Did y'all discuss your other motions pre-trial?
Yes, Your Honor, we did. We also have one housekeeping matter as well, but we can take care of that after the defense's motions.
Okay. All right, defense, what motions do you have?
Yes, Your Honor. The defense today has two motions in limine. Now, to provide some additional context, this case boils down to who had control over the area where the plaintiff's injuries occurred on the day of the accident. Now, after conferring with opposing counsel, we've been able to reach a stipulation as to one exhibit. That's exhibit 39. So opposing counsel has stated and is our understanding that that will not be admitted today.
So you guys are agreeing to exclude exhibit 39?
Yes, Your Honor, that's correct.
Okay. Very well.
So on a related note, Your Honor, exhibit 38 is an email from a supervisor and a Mr. Perry Hayden. Now, Perry Hayden is one of the witnesses in today's trial. He is an OSHA investigator. Now, exhibit 38 is problematic for two reasons. It violates hearsay under 801 and 802, as well as it would be improper character evidence under 404. Now, Your Honor, if it would help, I can have my co-counsel publish this exhibit so we can look at it as I discuss these issues.
That would be helpful.
Great. Mr. Meinkoth, if we could go ahead and put up exhibit 38. Thank you, Mr. Meinkoth. Now, Your Honor, first as to the hearsay issue, this is an email from Sebastian Bach, Mr. Hayden's supervisor, who will not be here to testify today. So this document is hearsay that does not fall under an exception to hearsay. But secondarily, Your Honor, and more problematic is the fact that this document specifically references Mr. Hayden as a pro-business kind of person. You can see that at the top of that second paragraph there. Now, this would be offered, and its only relevance is if it would be offered to show that Mr. Hayden acted in accordance with that business trait and decided to not cite the defendant for violations, even if maybe they should have been cited for violations. So that would be improper character evidence under 404, and that would be why we seek to exclude this exhibit.
In your response?
Yes, Your Honor, we do intend to use exhibit 38 today. We don't intend to offer it for its truth. Whether or not this person was pro-business, whether or not they were issuing more citations or not. Your Honor, the jury needs to know that the OSHA representative who was inspecting the business in today's case, that their mindset going into the situation and the statements that they gave for this trial today, Your Honor, they need to know what that person's bias might have been, and they also need to know whether or not that person's testimony is credible today. And that report and that email goes directly to the credibility of the witness.
Your Honor, if I may respond just briefly.
Very briefly.
Your Honor, whether or not this is offered for the truth of the matter asserted does not make it not character evidence. And what Mr. Hobbs just stated was exactly our concern, that they would be offering this to show that he was a pro-business kind of person that on this occasion acted in accordance with that. That's not bias, Your Honor, that is character evidence.
Okay, so what I'm going to do here is I am going to grant a motion in limine as to this evidence. Plaintiff, you are welcome to, if you get to a point you feel it's appropriate, whether you're ready to offer it in, as some kind of admissible character evidence, or if you're going to use it to impeach or whatever it is you plan on doing with it, you're welcome to approach the bench and ask at that time to use it.
Yes, Your Honor.
All right, plaintiff, let's go ahead and go over your housekeeping matters.
Yes, Your Honor. In the conversation that I had with Ms. Nichols before trial today, we did stipulate to pre-admit exhibits 16 through 30. That's 16 through 30. And so we would seek to admit those at this time, or we would admit those at this time.
That accurately reflects the agreement?
Yes, Your Honor, it does.
All right, let me mark those down as admitted. Very well. Anything else, plaintiff?
No, Your Honor, that concludes our pretrial motions for today.
Defense?
Yes, Your Honor. So just two quick matters. First, we would ask for the court's clarification as to the tendering of experts in deposition form as we have in today's trial. Is it sufficient for us to simply read out the portions of the deposition that would lay the foundation for expert testimony and then proceed on to the opinions in the deposition?
That is entirely up to y'all's reading the rules of evidence, and I'm not going to get in the middle of any argument y'all might have about that.
Understood, Your Honor. And in terms of admitting exhibits, we have found that it is most effective to have the witnesses pull up the exhibits on their computer, lay the foundation, admit them at that time, and then ask your permission to publish for the jury. Does that work for Your Honor?
Just follow me, whatever works for y'all.
Thank you, Your Honor. With that, the defense is ready to proceed to opening statements.
Okay. All right, plaintiff, you ready to start?
Yes, Your Honor. One moment to reposition.
Okay.
May I proceed, Your Honor?
You may.
Your Honor, opposing counsel, members of the jury. Dark, derailed, and dangerous. Members of the jury, in January of 2019, my client, Mr. Jordan Gilmore, was working at the plaintiff's department store, Chimes department store here in Waco, Texas. When he was injured while working in a dark stairwell near a derailed platform that created a dangerous condition in his work environment. And to understand where this story begins today, we have to take you back all the way to the beginning, over a decade ago, when Chimes department store first moved here to Waco. In 2005, the defendant sent an email to their landlord. And in that email, they said, subject line, loading dock. We are requesting landlord remove railing from the steps and landing area immediately outside the emergency exit doors at the rear of the building. We would like to use this area as a loading dock to allow us to bring products in and out of the building and load them on and off of trucks. The railing makes this impossible, so we need it gone. We need this done ASAP. And so it was done immediately. The railing around that stair and around that platform was taken away. Platform and the stairs were derailed and the stage was set. Now, almost 5 years later, in 2010, one of the defendant's employees was working in that area, in a place the defendant told him to be. And when that defendant was walking outside in that January day, in the cold and in the dark, that employee fell down the stairs on his face. And there was a report filed by the defendant after that incident happened. What can we do to stop this from happening again? The defendant's own words are to not have employees go out in the dark and to make sure that there is adequate lighting on that loading deck. In 2018, an OSHA representative shows up to do an inspection of the defendant's business. An OSHA representative walks outside and says, hey, what about that light up there? When the defendant turns and says, oh, don't worry about that. It's automatic. And now we're in January of 2019, when my client, Jordan Gilmore, is working his normal 12 to 8 shift there at Chimes department store. He goes outside to an area the defendant told him to be in. That light, still not on. And when the defendant tries to walk up those unrailed stairs, Jordan falls. And he is injured because of the dangerous condition that the defendant created when he made an unmade platform, an unrailed platform, and a dark staircase. Members of the jury, that dangerous condition is why we are here today. Good morning. My name is Matthew Hobbs, and along with my co-counsel Summer Combs, we represent the plaintiff, Jordan Gilmore, in today's case. Now, as the plaintiff, we carry the burden. We have to prove to you that it's more likely than not, by preponderance of the evidence, that the defendant knew or should have known about a dangerous condition in or around their business, and that they failed to take reasonable steps to warn or correct that danger for the safety of their employees. And we embrace that burden today. We're going to call a couple of witnesses for you to hear from today, and they're going to tell you about the dangerous conditions that were present at the defendant's store. The first person you're going to get to hear from today is Jordan Gilmore himself. Mr. Gilmore, would you mind turning on your camera? Members of the jury, this is Mr. Gilmore, a proud Texan, active in his church, and heck, he even plays cards with his friends on the weekend. Thank you, Mr. Gilmore. You can turn off your camera. When Mr. Gilmore takes the stand today, he's going to tell you about the condition of that back elevated platform at the defendant's business. He's going to tell you about how there was no rail, how there was no light, and how when complaints were raised about that railing and about that light, well, the defendant's response was, we have more important things to take care of. But you're not just going to get to hear from the defendant or from the plaintiff in today's case, Mr. Jordan. You're also going to get to hear from our own expert, Kelly. And Kelly is going to walk you through some of the rules and regulations that apply to businesses here in Waco. She's going to tell you how when she applied those rules and regulations to the defendant's business, that they failed to meet their obligations not only under OSHA, but under the International Business Code, which has been applied here in Waco. Members of the jury, after we're done with our case, I anticipate that the plaintiff or the defense is going to call some witnesses before you today. I anticipate that they're going to call the owner of Chimes Department Store. And when she takes the stand, she's going to try to distract you with who owned the business, hash marks on a map, whether there was control or not control. The members of the jury, don't get lost in the defendant's distractions. Focus on what you know and what you've heard. We also anticipate that you're going to get to hear from another witness from the defense today, an OSHA inspector. And when that inspector takes the stand, he's going to try to also distract you about certain rules and regulations that he believes apply. What you're going to find out is some of those rules and regulations, they've never been passed. The law that was relied upon by that OSHA representative was in fact not the law and is not the law today. By the end of today's case, the judge is going to come before you, and Judge Altman's going to tell you about the law that you have to apply in today's case. He's going to instruct you and charge you about what your duties and responsibilities are. He's going to walk you through the law, and he's going to explain how you should apply it. And I'm confident that when he is done explaining that law to you, you will be able to return a verdict of liable for the defendant Chimes Department Store because they had an unlit stairwell, a derailed platform, which created a dangerous condition in their workplace. Thank you.
Defense?
Yes, Your Honor, just a moment to set up the well. Can you see and hear me all right?
I can.
Great. Okay. On January 23rd, 2019, Mr. Gilmore went outside while taking a smoke break, went down a set of stairs with disintegrating concrete, took his smoke break, and then proceeded to go back up that set of stairs. And as he reached the top landing of those stairs, something happened. His foot slipped in an area that he had been in thousands of times before. And he severely injured himself. You see, members of the jury, we agree with Mr. Hobbs about what happened on January 3rd, 2019. But Mr. Hobbs left out a very important fact. And that is that the defendant today, Chimes Department Store, was not in control of the area where this accident occurred. Kermit Realty LLC, the property owners, which the defendant Chimes leased the property from, were in control of that landing. You see, this case today is about the failures of a corporation. But it's not about the failures of the men and women of Chimes Department Store. It's about the failures of a property owner to hold up their end of a bargain. You see, when Chimes Department Store leased their store area from Kermit Realty, they signed a lease. They agreed to pay Kermit Realty in regular installments, rent, and in exchange, Kermit Realty agreed to keep up their end of the bargain, to keep their areas that were in their control in safe conditions. They agreed to maintain those areas, but they didn't hold up their end of the bargain. Members of the jury, you will hear today that Kermit Realty LLC was both in control of the area where this accident happened and was also in charge and had agreed to maintain that area. Kermit was in control. And members of the jury, we're going to ask you to pay close attention to the pictures in today's case, because you're going to see this set of stairs. This is the set of stairs that Mr. Gilmore fell on the night of January 23rd. And any reasonable person walking by these stairs could see that they're in disrepair, can see that that concrete is crumbling to bits. So we ask you to pay close attention to that today, because that is what today's case is about. It's about what caused the injuries, as Mr. Hobbs said. But members of the jury, Mr. Hobbs mentioned some things that he called distractions, and I want to clarify something for you. Because as the jury today, something you will have to determine as a preliminary matter, before you determine anything else, is who had ownership and control of the area where this accident occurred. Who had ownership and control of those stairs? These stairs, whose job was it to make sure that this concrete was not falling apart? That is something you have to determine before you can even reach the issue of negligence or any other factors in today's case. So that is what this case is about. So let me introduce you to my client, Chimes Department Store. You see, Chimes Department Store is a small family-owned business. They're an important part of this community. And Chimes understands that they have a duty when individuals are on their property, in their store, in the areas in their control, that they have an important duty to protect those people, to make sure that area is maintained properly. However, the area where this accident occurred, members of the jury, was not an area where Chimes Department Store had control. Now, in today's trial, you'll hear a lot of terms and leases, potentially complicated legal terms. And we will show you that based on the lease, based on all the other legal documents, Kermit Realty had control of this property. But I want you to pay closer attention to the actions of the parties today and what those tell you about who had control of this property. You see, Mr. Hobbs mentioned that Chimes Department Store had requested the railing to be removed. He's right. We did. What he didn't mention is the fact that Chimes Department Store did not remove that railing. Kermit Realty did. Ask yourself today, as you're hearing the evidence, why would Kermit Realty incur the cost and the time to remove a railing if they didn't have control and weren't required to do that based on the lease? Ask yourself that question. Because regardless of who asked for the railing to be removed, Kermit Realty was in control of that area and ultimately approved of and removed that railing. You see, members of the jury, that is the preliminary question you have to answer today. Who was in control of that area? And as the evidence will show, it was Kermit, not Chimes. And at the end of this trial, if you find that that is the case, then Chimes cannot be found negligent. But we won't just stop there today, because we will also show you that Kermit Realty LLC was the negligent party today. We will show evidence that Kermit Realty knew of an unreasonable risk, knew or reasonably should have known that these stairs were unreasonably dangerous. Kermit Realty knew. We will show evidence that Kermit Realty had created this hazard, that Kermit Realty knew of this hazard, and that they failed to exercise something called ordinary care in fixing those steps. Because members of the jury, that night, it was derailed and it was dangerous. But that wasn't because of Chimes. That was because of Kermit Realty LLC. The evidence will show today that Kermit had allowed their premises, these concrete steps, to deteriorate into a state of disrepair. And that ultimately, members of the jury, Kermit was in control. So at the end of this trial, I will come back up here and I will review all of the evidence with you. And at that time, I will ask you to return the only verdict that aligns with justice. I will ask you to find Chimes department store, the store that had no control over the landing where this accident occurred, not guilty. Thank you.
Plaintiff, you want to call your first witness?
Yes, Your Honor. The plaintiff calls Jordan Gilmore to the stand.
Mr. Gilmore, you're constructively sworn.
May I proceed, Your Honor?
You may.
Good morning, Mr. Gilmore. Would you mind introducing yourself to the members of our jury?
Yes, my name is Jordan Gilmore.
And Mr. Gilmore, where do you currently live?
Currently live in Waco, Texas.
Are you employed here in Waco?
Not right now. I'm unemployed at the moment.
Why are you unemployed?
Well, I was fired by Chimes department store after the accident.
Were you working when you were injured in that accident?
Yes, sir.
How long had you worked at Chimes before you were injured?
Roughly 10 years, I'd say.
I want to talk about the accident, but first I want to ask you, Mr. Gilmore, did you used to smoke?
Yes, sir, I did.
And when you smoked, where at the building were you allowed to smoke?
We were instructed to only smoke in the back. We were specifically told not to smoke out front.
And where were you specifically told where to smoke, as far as that information coming to you goes?
Yes, sir. We were instructed to smoke out back by the dumpsters.
Was there any sort of memo sent by the defendant as to that effect?
Yes, sir, there was.
Would you recognize that memo if I were to show it to you now?
Yes, sir, I would.
Your Honor, I would ask that I have permission to have Ms. Combs publish to the defendant or my plaintiff here today, memo, Exhibit 1.
So you're just showing it to the witness?
Yes, Your Honor, constructively.
That's fine.
Now, Mr. Gilmore, do you recognize this exhibit?
Yes, sir, I do.
Does it appear to have been changed or altered in any way since the last time you saw it?
No, sir, I do not believe so.
At this time, Your Honor, the plaintiff moves to enter Exhibit 1 into evidence.
Any objections?
No objection, Your Honor.
Exhibit 1 is entered into evidence.
Now, if I could direct your attention to part of this exhibit, could you read out that first paragraph for us, Mr. Gilmore?
Yes, sir. I am sending you this memo to remind you that the owner does not want any employees taking smoke breaks in front of the store. Apparently, the last time Reese came by the store, someone was smoking out front. We can't have that. As you have been told before, if you're going to smoke, you need to smoke out behind the store where our dumpster is. That is the only place you should take smoke breaks on the premises.
Now, after you got that email from the management, did you listen to your employer?
Yes, sir. I always listen to my employer. I'm not a rule breaker. I want to listen to my employer.
Did you ever smoke out front?
No, sir. Not a single time.
Now that we've covered where you were smoking during your smoke breaks, I want to move to when you were injured. Do you remember January 23rd, 2019?
Like it was yesterday.
Where were you?
I was out back by the dumpster walking down the stairway.
And why were you out back by the dumpster?
Well, as I said before, that was where our employer made us take our smoke breaks if we were going to take a smoke break.
And what time were you out there by that dumpster?
I'd say roughly 7 o'clock. So it was pretty dark by that point. It was in the winter time, so the sun goes down early.
Was there any lighting in the back of the store?
No, sir.
Do you know if there was a switch to turn on any lighting?
I believe that there was a switch, but it was in the store next door. I believe it's the Tractor Supply store.
Now, did you or any of your fellow employees, did y'all ever complain about the lack of the lighting behind the store?
Absolutely.
So I want to discuss what happened specifically. You already told us that you went out there to smoke and you went down the steps that day. What happened whenever you were trying to climb back up those steps?
Well, as I was trying to climb back up, when you're going down, I would have to kind of hold myself up because it's dark and there's no railing on the left side. So I'd have to hold myself up, and as I was going back up, you have to hold yourself up to get around the door that comes out from the back on the platform.
Was there any sort of railing present on those stairs or that platform?
No, sir, not while I was there.
And you mentioned that you had to go around the door. Why did you have to go around that door?
Well, the platform's kind of small, so when it opens, it takes up most of the platform, and it only leaves a very narrow way for you to get up.
Now, we've already talked about leading up to the injury. Can you tell us what happened that resulted in your injuries?
So as I was walking back up, it was dark, and I was holding myself up, and I was scooting around the door that was in my way. And as I did, I lost my footing, and I fell back, and I landed on my right knee, and it roughed me up pretty bad.
Did you tell the manager that was on duty that day what happened?
Yes, sir, I did. I told Lane Kim that the
And
manager,
what did Miss Kim tell you?
she had asked me if I needed to go to the hospital.
Did she tell you anything about having notice of the stairs or the condition of the lights out back?
Yes, she had known about it because we had complained before.
And were you ever contacted by management at Chimes for a statement after you were injured?
Yes, I was. I was contacted to make a statement by the manager, Lane Kim.
And would you recognize that statement if I showed it to you today?
Yes, sir, I would.
Your Honor, I'd like to constructively show my witness here what has been previously marked as Exhibit 10.
Okay.
Do you recognize this exhibit?
Yes, sir, I do.
Mr. Gilmore, does it appear to have been changed or altered in any way since the last time you saw it?
No, sir, I do not believe so.
Your Honor, at this time, plaintiff moves to enter Exhibit 10 into evidence.
Any objections?
Yes, Your Honor. Specifically, we object to the first half of this document, everything above the line for Chimes purposes only. Everything above that line is hearsay within hearsay pursuant to 805. And although that can be admissible if both levels of hearsay are met, only one level of hearsay is met here as an opposing party statement. The statements by the individual reporting the accident are not made within their scope of employment or fall within any other exception to hearsay.
All right, hold up. Pause for 1 second. I do not see where it says Chimes purposes only on this exhibit.
I apologize, Your Honor. I can either republish or we can have opposing counsel scroll down, whichever is easiest.
Okay, so it's in the next page or something?
Yes, it's in the third page to be specific.
Okay, so your complaint is everything above for Chimes use only. Your objection is that it's hearsay and then also hearsay within hearsay. If I'm
Yes,
understanding.
Your Honor.
Okay. Response.
Yes, Your Honor. This statement was taken by a representative at Chimes in their official capacity as a representative for this injury when it happened or immediately thereafter it happened, Your Honor. Because of that, every single thing that is above that line has been adopted by the party opponent in today's case and therefore would be non-hearsay.
Okay, I've heard no predicate to that. I'm going to sustain the objection.
So directing your attention to the last page of that exhibit that we just had up in front of you, where it says for Chimes purposes only, what does it say that the manager at Chimes believed would have prevented this accident from happening? That second question down there.
That if I would have quit.
Okay, hold up. This exhibit in its entirety has not been admitted. I sustain the objection. You did not reoffer the part that has not been admitted. So we're not going to get into it till any part of it has been admitted.
Yes,
Are
Your
you
Honor.
offering just that section that defense does not have an objection to?
Yes, Your Honor, I would.
Okay, then we are going to constructively redact this document, everything above where it says for Chimes use only. And Exhibit 10 is admitted as to the part that is not constructively redacted.
Now, back to my question, Mr. Gilmore, what does the management at Chimes say would have prevented this accident from happening?
That if I would have quit smoking and don't go outside on the loading dock without making sure the lights were turned on.
And can you tell us again, the reason why you were out there was because
The management had told us to go back out there to take our smoke breaks out there when we went.
now, before I turn you over to defense counsel, Mr. Gilmore, I have a couple questions about the injuries that you sustained in today's case. You mentioned before that you were a smoker. Are you still a smoker now?
No, sir, I quit smoking. Once that accident happened, I thought it was God.
Objection, relevance, Your Honor.
Response?
Yes, Your Honor. In today's case, we have to prove that there was a proximate cause, which requires that we prove injury in today's case. Your Honor, I'm not going into any medication that my client is taking or any of the damages that he sustained as far as doctor's bills or continuing pain or suffering or anything like that. But Your Honor, according to the black letter law, we have to prove that there was an injury in today's case.
Your Honor, if I may elaborate.
You may.
My objection is not with testimony as to the fact that there are injuries in this case. My objection was the testimony that he's no longer a smoker, which has no pertinence to the injury he sustained on January 23rd, 2019.
Is there a connection there?
Yes, Your Honor. As a result of this accident, my witness is no longer smoking because of the severity of his injuries.
I'm going to overrule the objection and let you get into it. But I do think that's a pretty fine line there. But all right, we're going to overrule the objection for now.
Yes, Your Honor. Now, Mr. Gilmore, you said that you had surgery. Did you have any scarring as a result of that surgery?
Yes, sir, there's a pretty big scar on my right leg where I had that surgery.
And would you recognize a picture of that scarring if I showed it to you today?
Yes, sir, I would.
Ms. Combs, could you put up exhibit number 8 for us, please? Mr. Gilmore, is this the picture of the scarring on your knee?
Yes, sir, it is.
Does it appear to have been changed or altered in any way since the last time you saw it?
No, sir, all 28 staples are there.
At this time, plaintiff moves to enter exhibit 8 into evidence.
Any objections?
Yes, Your Honor, pursuant to relevance in 403. Again, this does not go to the fact of consequence of whether he was injured or not. The jury has already heard this testimony. This would be unduly prejudicial given that we aren't determining damages today.
I think one photo is probably not the point where we're overly cumulative. I'm going to overrule the objection.
Now, Mr. Gilmore, are you still in pain?
Yes, sir. I'm in a lot of pain. My right leg is very weak and I still have that scar and it's very painful.
No further questions at this time, Your Honor.
Any cross?
Yes, Your Honor.
Go ahead.
Good morning, Mr. Gilmore.
Good morning.
So I want to start by establishing some things that you don't have knowledge of today. You were not a manager at Chimes, correct?
I was not.
You were a cashier.
I was.
So you didn't have any knowledge of the lease or property agreements that Chimes was involved in?
No,
So you couldn't testify today as to who owned or didn't own portions of this property?
no, ma'am.
And you couldn't testify as to whose job it was to maintain those portions of the property?
No, ma'am.
So I want to then turn to what did not cause your fall on January 23rd, 2019. You would agree you were pretty familiar with that area out back of the building.
I was familiar, but it's still dark out there.
Well, I understand it was dark, but I want to do a little bit of math with you to establish how familiar you were. You would agree that you went out back of that building about 20 times per week.
Yes,
And 52 weeks in a year, that's about 1,000 trips a year, right?
yes,
And you had worked for Chimes department store for 10 years.
yes,
So in that time, you had gone out to that same area over 10,000 times.
yes.
So you were pretty familiar with its layout.
I was familiar, but it was still dark.
Well, let's talk about the fact that it was dark, because in no time in that 10 years had you ever had the ability to turn on the light switch out there, right?
No, I did not.
And in fact, you testified that it was a regular occurrence that that light was off.
Yes,
So it was a regular occurrence that that light was off during your 10,000 previous trips out and back of the building.
yes, ma'am.
So then with that understanding, let's talk about what might have caused the fall. In your own words, you stated as you reached the landing, you stepped up and put your foot onto the landing.
Yes, ma'am.
And then something happened and your foot slipped.
I was just trying to go around the door. Yes,
Right. And you can't testify as to exactly what happened when you slipped.
I don't remember.
Well, let's go ahead then. And I want to turn your attention to Exhibit 5 in your packet so that we can take a peek at that and better understand what happened that day. Would it be easier for you, Mr. Gilmore, if I had my co-chair constructively published to you before we admit the exhibit?
That's fine with me.
Great. Your Honor, permission for my co-chair to constructively publish to Mr. Gilmore.
Okay.
So, Mr. Gilmore, this is a diagram of that landing where you slipped that day, right?
Yes, ma'am.
And it fairly and accurately reflects the layout on January 23rd, 2019.
Yes, ma'am.
Then, Your Honor, at this time, we'd move Exhibit 5 into evidence.
Any objections?
No, Your Honor, I have no objections.
Exhibit 5 is admitted.
And oh, thank you. And then permission to publish to the jury now.
You may.
Thank you. So, Mr. Gilmore, you mentioned that you had to step around the door on direct. So I'm going to have Mr. Meinkoth put a red circle around about where that would be on this exhibit. Is that where you had to step to get around the door that day?
Well, I think that the depiction here, it's like it's straight up and down, but the door is more diagonal.
But to
So
be clear, Mr. Gilmore, you just stated that this was a fair and accurate depiction of this layout on the day of the accident, right?
well, it is a fair and accurate depiction of the platform.
And you testified on direct that you had to step around the door to get in that night, right?
Yes,
So you would agree with me that even if it's not exactly where that red circle is, you had to step somewhere around that door to get in.
yes,
Okay. I'm going to go ahead and turn your attention to Exhibit 6. Judge, Your Honor, permission for my co-counsel to constructively publish Exhibit 6 for the witness for admission
Okay.
purposes. Now, you recognize this photo as well, right?
yes,
This is another photo of that landing, but this time an actual photo instead of a depiction.
yes, ma'am.
And this fairly and accurately reflects the area where you fell that day.
Yes, ma'am.
And at this time, we move Exhibit 6 into evidence.
Any objections?
No, Your Honor, I have no objections to Exhibit 6.
Exhibit 6 is admitted.
And permission for my co-chair to go ahead and constructively publish Exhibit 7 to Mr. Gilmore. Or 17, excuse me, not 7.
17?
17, yes, Your Honor.
Yeah, 17's in evidence. You can do whatever you want to with it.
Thank you. Then permission for, we can publish. Great. Mr. Minkoff, we could please publish Exhibit 17. And I'm going to actually have him publish Exhibit 6 and Exhibit 17 side by side, Mr. Gilmore, so we can take a peek at those. So looking at these photos, Mr. Gilmore, you'd agree that these stairs were falling apart.
Yes, ma'am.
And you'd agree with me that in that top area, in that top right-hand corner of that landing where you had to put your foot that day, there's a chunk of concrete missing.
Yes, ma'am.
No further questions, Your Honor. We can take that down, Mr. Minkoff. Thank you.
Any redirect?
Yes, Your Honor. Briefly.
Okay.
Now, Mr. Gilmore, we discussed earlier that there wasn't a railing there the day that you fell. Would you have fallen if a railing was present?
Objection, speculation.
Sustained.
Mr. Gilmore, I want to go over some of the things that opposing counsel asked you about during their cross-examination. They mentioned that the stairs were falling apart on the back of the business. Were you required to go out there for anything other than smoking?
Yes, we were supposed to go out there to take the trash out.
And how often did you take the trash out when you were working?
At least twice a day.
And was there any other location where you were supposed to take trash?
No, so that was the only designated location.
No further questions, Your Honor.
Very well. Anything else for this witness?
No, Your Honor, I have nothing further.
All right. May this witness step down? Or you guys cool with me letting this witness step down, I should say?
Yes, Your Honor.
Mr. Gilmore, go ahead and take a seat. Thank you for your time. Plaintiff, any other witnesses?
Yes, Your Honor. We would call Kelly Danes by deposition in today's case.
Very well.
And I'll have my co-counsel reading the deposition here with me. She'll be responding as Kelly Danes as we go through this deposition.
Very well.
Starting on page 2, line 6. Can you please state your name for the record?
My name is Kelly Danes.
Now moving down to line 12, tell us about your education.
I have a bachelor's of science in mechanical engineering from the University of Wisconsin-Madison.
And finally to line 14, I noticed that your CV lists you as a PE. What is that?
It stands for professional engineer.
And now we're on to page 3, line 2. What do you have to do to become a professional engineer?
Well, you have to graduate from an accredited engineering program, which I did. Then you have to pass the fundamentals of an engineering exam, which I did. Then you work as an engineer for 4 years before you take the professional engineering exam. So I took that as well and I passed.
Now moving down to line 13, what do you do professionally?
I'm the president of Danes Engineering LLC.
And what does your company do?
We provide forensic and investigative engineering consulting and litigation support, specializing in industrial, commercial, and construction engineering, operations, safety, patents, and regulations.
Now moving on to page 4, line 7. How long have you been in business as Danes Engineering LLC?
I've been doing that for the past 10 years.
Now down to line 14. How many incidents have you investigated?
Over 60.
Now down to line 19. And how many times have you testified at trial?
Twice prior to this.
Moving now to page 5, line 11. Do you charge the same rate for testifying at trial and depositions as you did for your previous work?
Yes.
And now to line 15. What did you review in coming to your opinion in this case?
I reviewed the deposition of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, and a number of provisions from the International Building Code. And I conducted an inspection of the location of the fall and took pictures of that area.
At this time, Your Honor, plaintiff moves to tender Ms. Kelly Danes here as an expert in litigation support, specializing in industrial, commercial, and construction engineering, operations, safety, patents, and regulations.
Any objections?
No objection, Your Honor.
Okay, the court will then accept Ms. Daines as a expert witness in the fields listed.
Moving now to page 6, line 7. Did you take any photographs during that inspection?
I did.
I'm showing you what has been marked as exhibits 16 through 21. Do you recognize these?
Yes.
Your Honor, we would seek to enter exhibits 16 through 21 at this time. I believe they've already been entered into evidence, so
They've
I'll
already
redact.
been-
Yes, Your Honor. May we, Ms. Combs, could you put up exhibit 17 for us? What do these pictures show?
Well, as you can see, there are no railings on the steps up to the landing area, and there is no railings on the landing area itself. Plus, you can see where the railing used to go into the concrete and how the concrete around those areas is worn down and cracked. So you can see that this is a pretty dangerous situation.
Moving now to page 7, line 1. I'm showing you what has been marked as exhibits 22 through 30. Do you recognize these?
Yes.
Ms. Combs, could you put up exhibit 22 for us? And 29 if you have that one. What do these pictures show us?
Well, there are multiple stores in that little strip center, and they all have some kind of landing area and steps behind them, just like Chimes. However, as you can see from these photographs, nobody else has removed the railings from those areas. So what you see in these photographs is what the landing area behind Chimes would have looked like with railings and what it should have looked like in order to be safe.
Moving now to page 8, line 16. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question, and the facilities in question must be in compliance with those codes and regulations.
What is the basis for that opinion?
Well, in regards to the International Building Code, the city of Waco adopted that code and incorporated it into its own city ordinances on March 20th, 2001. The OSHA regulations were enacted into law in 1970. So both the IBC and OSHA regulations would apply to whoever was responsible for the maintenance and repair of the area where this incident occurred.
Moving line now to page 9, line 14. Why are those regulations significant in this case?
These are general provisions that require an employer and or a party that is responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition, free from recognized hazards. Here, as you can see from the photographs that we've looked at, that I took during my inspection of the stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of a light switch to turn on the light above the stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant didn't have such a program and never identified or corrected these hazards. So fairly clearly, the defendant violated these requirements under both the IBC and the OSHA regulations.
Moving now to page 11, line 6. What other portions of the IBC codes and the OSHA regulations do you find important in this case?
OSHA 1910.37 subsection B1 and IBC 1006.1, which both deal with lighting.
And why are those significant?
Well, 1910.37B requires that lighting must be adequate and appropriate for a building exit like this one. And 1006.1 requires that any means of egress must be illuminated at all times the building is being occupied. In this case, there was a light above the stairs, but there was no switch for that light inside the Chimes store. So there was no way for the employees to turn that light on when they went outside at night. A switch like that should have been installed long before this incident to make sure that employees could see where they're stepping.
Moving to line 24 on that same page, what's next?
Next, we move to OSHA 1910.23 subsection D1 and 1910.24H and IBC 1009.11.
And now we're on page 12, line 3. Why are those significant?
All of these provisions require that stairways or flights of stairs must have guardrails or railings on any exposed side. Here, there was no guardrail on these stairs on the exposed side, which is obviously dangerous.
Do you know if there was ever a guardrail on those stairs?
Yes, there was, and it was removed at some point.
How do you know that?
You can just look at the photographs and see where the guardrail used to be on those stairs. You can see the broken off piping in the concrete.
Moving now to page 13, line 16. All right, anything else?
Let's take a look at OSHA 1910.24H and IBC 10121 and 1910.24H. Or excuse me, 1910.24H requires railings on all stair platforms, and 10121 requires guardrails on all landings that are located more than 30 inches above the ground. In this case, as you can see from the photographs, I measured the distance from the ground to the top of the landing, and it was 34 inches. So this landing would be subject to both standards.
Moving now to page 14, line 5. Do either 1910.24 or 1012.1 apply to loading docks?
They don't mention loading docks specifically, but this wasn't a loading dock.
Now, why do you say that?
Well, just look at how it was used. Employees use this area to throw trash in the dumpster, and they use it to take smoke breaks. So this wasn't just a loading dock.
Now down to line 22 on that same page. Anything else?
IBC 10052 states that doors opening into the path of egress travel shall not reduce the required width to less than 1/2 during the course of the swing, and that when fully opened, the door shall not project more than 7 inches into the required width. When the door is open like it was at the time of the incident, it obstructs the path up or down the stairs to a 1-foot space between the edge of the door and the edge of the platform or the stairs where the plaintiff fell.
Now on to page 15, line 7. Any final thoughts?
Honestly, I just don't know what the defendant was doing here. All of this could have easily been fixed by putting up a guardrail around those.
Objection to speculation, Your Honor.
Response?
Your Honor, may I respond, Your Honor?
Yeah.
Your Honor, this is an expert's opinion about what should have been done to protect the employees of this workspace. She's allowed to testify as to what the code requires and allowed to testify as to whether or not the defendant was meeting the code expectations and requirements in today's case.
Your Honor, if I may.
You may.
My problem with her testimony is when she steps into the realm of whether or not this accident would have happened and all of this could have been fixed, Your Honor. That language implies that this witness is testifying that this accident wouldn't have happened, which is certainly not within her area of expertise.
Overrule the objection.
Back to that question, Ms. Combs, if we could start again on line 7, I'll re-ask my question. Any final thoughts?
Honestly, I just don't know what the defendant was doing here. All of this could have easily been fixed by putting up a guardrail around those stairs and landing and patching the cracked concrete on the steps. It would have been easy. And if the defendant had taken these simple steps, putting a guardrail along those stairs, putting a guardrail around that landing, making sure it was well lit, patching the concrete, then the plaintiff's fall would not have happened.
Your Honor, I just seek to preserve my objection to that line of questioning as well,
You
given my
made the
earlier.
objection. It's preserved.
Thank you.
Your Honor, that finishes the testimony that we would read from the deposition. Before I turn it over to my opposing counsel, the plaintiff would enter copies of CFR 1910.37B1, IBM 1006.1, CFR 1910.24H, and IBM 1012.1.
Are these exhibits or what are we doing?
Your Honor, these are photographs or not photographs, Your Honor, these are the law and regulations that would be or are applied to businesses and buildings here in the city of Waco.
Any objections?
No, Your Honor. I think the witness testified to these, so I guess it might be cumulative, but I don't have an objection to it at this point.
Okay. I mean, if you don't have any objections, then I suppose, sure. I suppose there'll be exhibits to keep the numbering 41 through.
There were 4 different ones, so it'd be 41 through 45, Your Honor.
Sure.
And Your Honor, with that, I have no further questions for this witness.
Okay. Ms. Nichols, understanding the fact that you have the ability to offer your case however you'd like, would you like to go ahead and go into this deposition at this time, or would you like to wait until your case in chief and bring this deposition back up?
We'd like to go into it at this time.
That's my preference as well. So go ahead.
Thank you. So we're going to begin on page 3, line 22. Question, based on what you do for a living, is it fair to assume that you regularly testify in lawsuits?
Yes, no question about it. I testify and work as an expert on cases on a regular basis. To be honest, preparing expert opinions in lawsuits like this one, testifying in depositions, and testifying at trials are about 99% of what I do at this point.
Moving to page 4, line 21. How did you get involved in this case?
I got a call from the firm representing the plaintiff, Jordan Gilmore. It's a firm I've done work for in the past, so this isn't the first time I've consulted in one of their cases.
Guess that means they like what you did in those other cases.
What can I say? I'm good at what I do.
Objection, Your Honor, speculation.
Overruled.
Kelly, I'm showing you what's been marked as Exhibit 15. Do you recognize this?
Yes, it is an invoice for the work that I've done so far on this case, which obviously doesn't include my time today or my time for testifying at trial if I have to do that.
Is Exhibit 15 a true and correct copy of the invoice of your work on this case up to this point?
Yes, it is.
And Your Honor, this time we move Exhibit 15 into evidence.
Any objections?
Yes, Your Honor, hearsay.
Your Honor, if I may.
You may.
This falls under the business record exception under 8036.
Do we have any predicate that it falls under the business record exception?
Yes, Your Honor, this is an invoice for her time that was regularly kept in her business. It was stored in that manner. This is just a regular document that she kept every time she invoiced a customer. So it falls under that exception.
Your Honor, may I respond to that?
You may.
We have no affidavit from the keeper of this record that an opposing party is offering at this point in time, stating that this is accurate or has been kept in accordance with the record keeping practices of the business, which is also required for the business record exception.
I mean, while an affidavit's not necessarily required to be testified to at trial, there has been no predicate laying out this meets a business record exception. Are you in fact offering this for the truth, or are you offering this to show potential bias?
We're offering this to show potential bias, Your Honor.
Okay, on that basis, I will overrule the objection.
Yes, Your Honor.
Moving now, Mr. Daines in this case, down to page 9, line 4. Do you know or have any opinion of who was responsible for the maintenance and repair of these steps behind the Chimes store?
No, that's not what I was asked to do. I assume it was Chimes, but that is just a guess.
So moving down now to page 10, line 4. Let me ask you this. If Chimes wasn't responsible for maintaining that area where the stairs were located in the back of the store, would the IBC apply to Chimes in regards to that area?
No, it wouldn't. The IBC applies to whoever has the responsibility to maintain that area.
No further questions for this witness, Your Honor.
Any other witnesses you'd like to call?
No, Your Honor. With that, the plaintiff concludes our case in chief.
Very well. Typically, I don't see any rules saying we can't take a 5 or 10 minute break. Are there any motions that need to be heard by the court prior to a break?
Yes, Your Honor, we have a Rule 50 motion for judgment as a matter of law, but we can do that before or after the break.
Why don't we go ahead and take care of it now?
Understood, Your Honor. Your Honor, pursuant to Rule 50, And in viewing the evidence in the light most favorable to the non-moving party, no reasonable juror could find that Chimes department store was negligent in today's case. And Your Honor, the reason is that the plaintiff has yet to prove ownership, which is something that needed to be proven prior to meeting any of the negligence elements. If Chimes was not the owner or not in control of that landing, then they cannot be found negligent in today's case. The only piece of evidence that they've shown that was on Chimes property itself, that we know at this point in trial was on Chimes property, was the light switch. So that portion of the testimony we understand could proceed to the jury. However, the railing and the concrete has not been shown to be in an area of their control. The only thing that the plaintiff has proffered is that the defendant told their employees to go there. That certainly does not meet the legal standard of ownership. So with that, we'd move for judgment as a matter of law.
Response?
Yes, Your Honor. There are two ways that we can prove control. We can prove that via a contractual argument, or we can prove that via actual control of the space. Your Honor, we've offered evidence today that the defendant placed their dumpsters in this area, had their employees using that area to load and unload cargo all the time, had their employees use that area as a break space and a smoking area. We've also proven that without the landlord's permission, they placed their dumpsters back there and had their employees throwing garbage away. Your Honor, that does show control in a light most favorable to the non-moving party, that being the plaintiff at this time.
Your Honor, if I may just have a clarification for the record.
Well, I actually would just like to ask, my understanding, I've heard no evidence that they, without the landlord's permission, put the dumpsters back there. Did I miss something?
No, Your Honor, I believe I misspoke, and I'll retract that statement, Your Honor. But they did have that space being used by their employees on a regular basis for unloading and loading cargo, as well as taking out trash and as a break area.
Yeah, I just want to make sure we're all on the same page on what I
Yes,
heard.
Your Honor.
I missed anything. The motion's denied. All right, so we're gonna go ahead and take a, let's say, 10-minute break with an exact 10 minutes. So at 11:12, we'll be back here.
Yes, Your Honor.
Any objections to that? All right, I will see you all at 11:12. All right, is everyone back?
Yes, Your Honor, the plaintiff's here.
We've got our judges. We're missing one judge. Got all our judges. Awesome. And plaintiff defense. Sweet. All right, then let's get rolling. When we left off, we had just handled a mid-trial motion. It is now the defense case in chief. So, defense, take it away.
Yes, Your Honor. At this time, the defense calls Ms. Reese Geller to the stand.
Okay, Ms. Geller. Ms. Geller, you are constructively sworn. Go ahead.
Thank you, Your Honor. Good morning, Ms. Geller. Can you please introduce yourself and spell your last name for the jury?
Yes, good morning. My name is Reese Geller, and last name is spelled Geller.
And Ms. Geller, what is your role in today's case?
I'm the defendant and owner of Chimes Department Stores.
Then let's go ahead and let the jury get to know you a little bit more. How long have you been working for Chimes?
Oh, I mean, it's been my entire life. It's a family business.
And what all positions have you held at Chimes?
Well, it really, because it started with my grandparents and I worked from the bottom up. And so I started out in the buying department, and then I worked in purchasing products. And now for past 10 years, I've been the owner.
Now, before we go any further, I want to address some things that Mr. Hobbs has mentioned during trial today. We've heard a lot of talk about guardrails. Now, were there guardrails out in back where Mr. Gilmore fell?
No, there weren't.
And why were there not guardrails?
There were, but we had our landlord, Kermit Realty Group, remove them because it's our loading area.
Now, Ms. Geller, please listen closely. Why did you not just remove the guardrails?
Well, I mean, we can't really do that. That's our landlord. So we had to, call them and ask, and they had to come out and do it. And so we couldn't just take it upon ourselves. It's not part of our leased area.
And Ms. Geller, did Kermit ever object to them being removed or tell you they couldn't be removed?
Objection, hearsay.
Response?
Your Honor, this goes to the effect on the listener.
Any response to that?
Your Honor, I don't see what effect this would have on a listener, whether they objected or anything like that. It's still hearsay.
Your Honor, if I may.
You may.
It's not hearsay if it is for the effect on the listener, as long as it's relevant. And here, Mr. Hobbs has been arguing that the defendant was on notice as a part of his theory of negligence. If the defendant was not on notice that there was any reason to object, then this is for the non-hearsay purpose of the effect on the listener.
Okay, I'm going to overrule.
So, Ms. Geller, did Kermit Realty ever object to them being removed?
No, not at all. They did it.
And just briefly, Ms. Geller, I want to talk about this light we've heard mentioned a lot today. Was there a light switch to the light out back on your premises?
There was.
Well, Ms. Geller, was there a light switch that your employees had access to?
No, there wasn't.
And at the time of the accident or before that accident, would it have been feasible for you to have put in a switch?
I mean, I guess, yeah, I guess you could say, sure, feasible.
Then let's go ahead and turn to who had control of the area where the accident occurred. I'm going to go ahead and, well, before we go into that, Ms. Geller, were you involved with the negotiations of the lease between Kermit and Chimes?
I mean, I was there, of course, because it was part of our business, but my dad did mostly at that, working with Kermit. We didn't draft it or anything like that. It was Kermit did that.
Understood. And so you're aware of the terms in that lease?
Yeah, I'm aware. Yeah.
I'm going to go ahead and have you turn to Exhibit 11 in your packet then, and let me know when you're there.
Sure. Yes, I've got it pulled up.
Do you recognize this document?
I do.
What is this a document of?
This is it's titled the Shopping Center Lease Agreement. And it's our lease agreement with Kermit Realty Group.
So does this lease agreement affect your interest in the property where Chimes Department Store is?
Yes,
And does it fairly and accurately reflect the lease agreement?
it does. Yes.
And Your Honor, at this time, we move Exhibit 11 into evidence.
Any objections?
Yes, Your Honor. This document is replete with hearsay and hearsay within hearsay statements, both from Kermit Realty and from the defendant in today's case.
Your Honor, if I may respond.
You may.
This document falls under 803.15, a statement and document that affects an interest in property. I would need opposing counsel to point to any specific hearsay within hearsay statements, because my understanding is that it is the statements of Kermit Realty and the statements of the property owner or of Chimes Department Store. So that would just be one level of hearsay and fall under 803.15.
Any objection or any response to 803.15?
Your Honor, this document may be a property interest document. However, I don't believe that it meets the exception under 803.15. Under that exception, we have several different requirements that have to be met for that to be met in today's case. It has to deal with the later dealings of the property that are inconsistent with the truth of the statements that are contained or purported in that document. And that's the only way that these documents are allowed to come in, Your Honor.
I mean, are you suggesting that whether or not there's an ownership interest in a leasehold isn't affected by the lease? I'm confused as what you're suggesting.
Your Honor, that has already been established. We understand who the representatives are of both the defendant and of Kermit Realty. We don't need this document to establish that. And furthermore, it is still hearsay, Your Honor.
Right, but it's hearsay means an exception, right? So I guess this is a conversation I'm having with you is, are you suggesting this exception does not apply to this document?
No, Your Honor, I'm not.
So you agree this exception applies to the document?
Yes, Your Honor.
Okay, therefore the objection is overruled.
Yes, Your Honor.
Is the exhibit admitted, Your Honor?
The exhibit is.
Thank you. And may my co-counsel publish?
You may, and by the way, I'm going to apologize. My camera has decided it no longer wants to focus. So the blurred thing is not intentional.
That's okay. We can hear you just fine still.
Good.
Mr. Meinko, that we can go ahead. Perfect. Thank you. So, Ms. Geller, I'm going to go ahead. Oh, thank you. Ms. Geller, I'm going to go ahead and have my co-counsel zoom in on this last 1.10 section where it says demised premises.
Okay.
Can you go ahead and read for us what the definition of a demised premises is?
Sure. Approximately 18,000 square feet of space in the shopping center, and being the space cross-hatched on the site plan, which shall have a minimum of 100 feet of clear interior width.
And I'm going to have you briefly turn to Exhibit 12 in your packet, Ms. Geller.
Okay,
Let me know when you're there.
I have it.
And do you recognize this diagram?
Yes, I do.
And what is this a diagram of?
This is looks like it's a copy of the site plan for our department store.
And does it fairly and accurately reflect the site plan?
Yes, it does.
Then, Your Honor, at this time we move Exhibit 12 into evidence.
Any objections?
No objections, Your Honor.
Exhibit 12 is admitted.
May we publish?
You may.
Thank you. So looking at this site plan, Ms. Geller, where is the area that you leased?
Our area that is leased is the area that's cross-hatched.
Okay, and where did the accident occur?
Where that red X is.
So was that red X area in the cross-hatched portion?
No, it wasn't.
So was that in the area which you leased?
No, it wasn't.
Thank you. I'm going to have you go ahead and I'm going to have Mr. Meinkoth turn to page 9. Your Honor, if we can have permission to republish page 9 of Exhibit 11 that was just admitted.
Page 9 of Exhibit 11. Yeah.
Yes, thank you. And we're going to zoom in here on the definition section here on the bottom.
Yeah.
Ms. Geller, can you read to us the definition of common area from this document?
Sure. The term common area is defined for all purposes of this lease as that part of the shopping center intended for the common use of all tenants, including among other facilities, as such may be applicable to the shopping center, parking areas, private streets and alleys, landscaping, curbs, loading areas, sidewalks, malls, and promenades, enclosed or otherwise, lighting facilities, drinking.
Great. And I'm going to go ahead and have us turn to the next page, 6.3, and zoom in on that one as well. So Ms. Geller, according to this language, can you read to us who is responsible for the maintenance of that area?
Sure. Landlord shall be responsible for the good and safe operation, management, and maintenance of the common area, and landlord shall operate, manage, and maintain the common area in good, attractive, and safe condition during the lease term.
Thank you, Ms. Geller. Mr. Meinquith, we can take that down. No further questions, Your Honor.
Any cross?
Yes, Your Honor. Now, Ms. Gellers, I just want to walk through a couple of the things that you talked about during your direct examination. You spoke earlier about your company's lease and the relationship with the landlord. Now, your landlord doesn't employ any of Chime's employees, do they?
No, they don't.
And Mr. Gilmore, he wasn't an employee of your landlord.
No.
And with respect to what you're referring to as the location where the accident happened, it was directly outside your store.
Yes, it was in an area that wasn't leased to us.
And you could ask to make changes to that area.
Yes.
And with respect to its use, you doubt anyone else used it like Chimes did, right?
Oh, I have no idea that. I mean, I didn't watch it 24 hours a day. I had no idea who was walking behind there.
But just to be clear, you doubt anyone else used it like your employees did, correct?
Yeah, I mean, we used the back of that area. And so, sure, I don't think I know of anyone that would be doing the same thing.
And based upon your own personal knowledge and observations, you've never seen or heard of any other person or entity using that space in any way since 2005 when Chimes moved in, correct?
That is correct. I believe so.
And nobody else cleaned that area?
No. I mean,
And in fact, I'm sorry, go ahead.
no, you're fine. I was just going to say we all just kind of kept it clean ourselves, just on each of our own parts.
That's right. And your employees at Chimes, you actually asked them to make sure that they were picking up in that back area, correct?
Well, yeah, I mean, kind of anywhere you go, you'd want to do that, but yeah.
Absolutely. Keep the business clean. Got to do that. Now, as part of keeping your business clean, you actually had some dumpsters delivered back there.
We did.
And you didn't ask your landlord to have those dumpsters delivered to the back part of your store, did you?
No, because we weren't altering the back of that area in any way, really, just adding the dumpsters.
But just to be clear, you didn't ask your landlord whether you could use space that you weren't leasing for your dumpsters, did you?
We didn't, no. You may have mentioned it, honestly, but no.
Now, I want to take us back to 2005 when your department store moved to its current location. You actually sent a request to remove the back railing to your landlord shortly after you moved there.
We did, yeah.
And you'd recognize that email if I showed it to you today?
Sure, yeah, I'm sure I would.
Do you have a trial book in front of you right now with the exhibits in it?
Yeah, I do.
Could you let me know whenever you get to exhibit 13?
I got it pulled up.
Now, that exhibit doesn't appear to have been changed or altered in any way since the last time you saw it.
No.
At this time, Your Honor, plaintiff moves to enter exhibit 13 into evidence.
Any objections?
No objections, Your Honor.
Exhibit 13 is admitted.
Ms. Combs, can we publish that to the jury? Now, I want to take a moment and read through some of the parts of this email here, and just correct me if I read anything wrong. The subject line says loading dock, and then underneath that it says Reginald. Per the terms of our lease, we are requesting that Kermit Realty Group LLC as landlord remove the railing from the steps and landing area behind our premises immediately outside the emergency exit doors at the rear of the building. We would like to use this area as a loading dock to allow us to bring products in and out of the building and load them easily off and onto trucks when necessary. The railing makes that impossible, so we need it gone. Per the terms of our lease, Chimes will reimburse Kermit for any costs associated with this work since it is being done at our request. We need this done ASAP. Thanks, Richard Geller. That's correct, isn't it?
Yep, that's correct.
Now, you wanted those railings gone on the platform and stairs so you could move more of your product in and out of your business.
Yeah, 'cause it's a loading dock, so we kind of defeated the whole purpose to have them there.
Absolutely. And moving now to 2010, 5 years after you had that railing removed, one of your employees was actually injured while walking down those same stairs.
Yes.
Objection, hearsay, Your Honor.
Yeah,
Can I
you're gonna
elaborate?
you're gonna need to elaborate on that a little bit.
Yes, Your Honor. So I believe that counsel is referring to another incident report that mirrors the incident report we dealt with earlier, in which the factual portions of that report, which he just referenced about an employee falling, would be hearsay within hearsay under 808, 805 under the same exceptions and inadmissible for the same purposes as the incident report in question that we dealt with earlier.
So he hasn't yet asked any questions in regards to any kind of incident report or any statements. So far, the only question I have heard, and correct me if I'm wrong, the only question I have heard is there was an incident on such and such a date where an employee was injured. Am I correct on what I heard?
You are correct, Your Honor. The only basis for that opinion, though, is from that hearsay document.
That's not an opinion, right? He's asking her a fact. There wasn't a employee injured, correct?
That is what he is asking her,
Okay.
Your Honor, but this witness is
The
knowledge based
objection's
on-
overruled.
And now, Ms. Gellers, whenever somebody gets injured on your premises, you have your managers fill out a report for them, right?
Yes.
And that report is kept in the regular practice of your business, correct? For any injuries that take place?
Yes.
And your managers are supposed to take those records shortly after those injuries take place.
Yes.
And you'd recognize that recorded statement of Jason Stiles, the person who was injured in 2010, wouldn't you?
Maybe. Yes.
If you could turn in your exhibit book that you have in front of you to exhibit 14,
Yeah.
take a brief look through the couple pages that it has. Does it appear to have been changed or altered in any way since the last time you saw it?
No.
And this is the incident report that was filled out by your managers after the accident with Jason Stiles, correct?
Yeah.
Your Honor, at this time, I would move to enter Exhibit 14 and to admit the rest of Exhibit 10 as the predicate to this being a regularly conducted business practice and record has been met for both of those documents at this time.
Okay, well, we'll handle Exhibit 10 in a few minutes.
Yes, Your Honor.
Hear any predicate in regards to Exhibit 10. However, for Exhibit 14, are there any objections?
Yes, Your Honor, this does not fall under the business records exception, as it is not done regularly within the definition of 8036. It's done sporadically anytime an accident happens, but it's not kept in the regular course of business, as the 8036 requirement requires, for the 8036 exception requires for there to be a level of authenticity or a level of reliability to this evidence. This evidence would not meet that standard.
Your Honor, may I respond?
You may.
All of the exhibits in today's case have been stipulated as authentic and original. In addition, Your Honor, the witness just stated that any time that there's an incident that takes place on their premises, they fill out one of these reports. This is that makes this a regularly conducted business practice.
Overruled. As in regards to the document itself, is there any further objections to the document?
Your Honor, I would just reassert my hearsay within hearsay objection from the earlier document for the sake of the record.
Well, so that, I guess that's my point, right? So the document itself fits the record exception, is what I'm saying. Are you suggesting there is hearsay within that document that we also need to handle?
Yes, yes, Your Honor, not your document. The top portion of the document is the statements of the employee given to the manager at the store, and the employee was not acting within the scope of her employment in making these statements to the manager.
Okay, so that brings us to the next point, I guess, because the objection was hearsay within hearsay. So record exception gets us under that first deal. The document itself, I'm ruling that it meets the business record predicate, business record exception. What about the alleged hearsay within the document?
Yes, Your Honor. These were taken from employees of the business by employees of the business as a part of the activity that was conducted. Therefore, both parties in this instance are agents of the business and employees of the business, and therefore every part of the document would be an opposing party statement and therefore non-hearsay.
Response?
Yes, Your Honor. The employee making the statement is not acting within the scope of her employment as required for 801D2. The employee would have to be acting within their scope of their employment for that exception to apply. And April Nardini, the individual reporting this accident, was not acting within her scope of employment when reporting a fall.
Okay, wait, I'm sorry. Who's April Nardini? My understanding was to do something with Jason Stiles.
Yes, Your Honor. Jason Stiles was the manager making the report. April Nardini was the one who fell and was reporting to Jason Stiles what happened.
Okay.
Just really quick, Your Honor, I think that my Miss Nichols has that flipped. Jason Stiles is the person who was injured, and April Nardini was.
I apologize. Yes.
All good. April Nardini was the manager at the time.
Okay.
And everything that's in this report was adopted by the business whenever they made it one of their official business records.
Okay. So have we heard any evidence that them making a business record means they adopt and behold it to be true any of those statements? Right, because my understanding of Miss Nichols' response here, right, is that if for this purpose the injured employee is actually contrary to the interests of the business because they're injured and making a complaint, basically, therefore not operating within their course and scope, right? It's not part of their duties that they make this report when they're injured. So it's not operating the course and scope, therefore is not a party opponent statement. My understanding of your response is that it is a course and scope because the company adopted it. Have we heard any evidence that the company adopts that, or are they simply recording the complaint?
Your Honor, we see that throughout this recorded statement that the first line is, "My name is April Nardini and I'm interviewing Jason Stiles by telephone." By the rest of this document, it's all based upon questions that were being asked by the employee as a part of this document itself. Whether or not these statements are adverse to the party in today's case doesn't necessarily mean that they are not party opponent statements. A statement can be adverse and still a party opponent statement. And this was taken in the official capacity of April Nardini as a manager and Jason Stiles as an employee of the defendant's business.
Right. The record itself, we've already established, I'm agreeing with you as a business record.
Yes, Your Honor.
The statements of Jason Stiles, right? I'm not getting the name wrong. The statements of Jason Stiles are currently been objected to as hearsay. Jason Stiles is not a party to this lawsuit.
No, Your Honor. Jason Stiles was an employee of the business.
Right. So you're saying the statements Jason Stiles made were, as an employee of the business, were in the course and scope of his employment, therefore fits on the party opponent anyways.
Yes, Your Honor.
The argument that Ms. Nichols is making, to my understanding, is that those statements by Jason Stiles are not within the course and scope because they are contrary to the defendant here in a separate case. Right. And he is not operating in course and scope when he is contrary to the defendant, which I find to be a persuasive argument. I'm asking, what is your response to that?
Yes, Your Honor. In responding to that, we would simply use this statement and the statements of Jason Nichols to show that the defendant was on notice as to the dangerous condition behind their business. So we don't need it for its truth value, Your Honor. We just needed to show that the defendant was on notice as to the statements of Jason Stiles when he was injured on the premises of the defendant.
Okay. Any response to this new argument that it's not for the truth, it's for, I suppose, affecting the listener or whatever?
Yes, Your Honor. To be relevant for notice, the statements in this document would have to be true because the employee would have to have fallen for the company to have been on notice. So for it to be offered for notice, it's not relevant unless it is true. Therefore, it's not a valid non-hearsay purpose.
I'm going to sustain the objection.
And just to be clear, Your Honor, that's just, and Ms. Nichols, correct me if I'm wrong here. Are we excluding the bit where it's, where were you when the accident happened? What parts are you referencing as the statements of Jason Stiles?
My understanding of the objection was it's all things above the 4 chimes use only, the same
Okay.
as was for Exhibit 10.
That is
Perfect.
my understanding as well, Your Honor.
Just wanted to make sure I understood where we were at, Your Honor.
All right. Is your intention to offer this under those conditions?
Yes, Your Honor. Just that last little bit on the end of this exhibit.
Okay, very well. So Exhibit 14 is redacted to reflect all the hearsay north of chimes purposes only being redacted.
Now, Ms. Gellers, I want to turn to the last page of that exhibit where it says for chime purposes only.
Mhm.
Underneath that, it says, what in your opinion could the employee have done to prevent this accident? And the response from your manager is not gone outside in the dark. I read that correctly, didn't I?
You did.
And underneath that, there's another sentence that asks, are there any steps that should be taken by chimes to help prevent such injuries in the future? To which your manager responded, make sure there is adequate lighting on the loading dock. I read that correctly, didn't I?
Yes.
Now, it's your opinion that you didn't do anything wrong when it came to the back deck of your business because it wasn't your job to fix any of that.
Yeah, that's right. It was on Kermit because of our lease.
I want to move on to 2018 during an OSHA inspection. You were visited by an OSHA inspector in 2018.
Frankly, I don't remember that, but I'm sure if you've got that in front of you, I can see what you're talking about.
You don't remember if you were visited by an OSHA inspector as the owner of Chimes in 2018?
No, we had managers. I mean, I could have been there, but it's 2018. So sure, I'm sure we were visited.
So I want to turn now to the injury that happened to Miss Jordan, or Mr. Jordan in this case. You were here today when Mr. Jordan was talking about his injuries, weren't you?
Yes.
And in 2019, you still hadn't installed a railing on the back balcony there or the stairs, had you?
Well, we couldn't. I mean, it's our loading dock.
But to be clear, you didn't have any railing on that balcony or the stairs.
That's correct.
And you still hadn't fixed the light or moved the light switch so that your employees could turn on the light if it was dark outside.
In 2019 is what you said?
Yes, ma'am, that's correct.
Okay. I mean, we installed the light inside of our building because that's the part we lease. So we didn't make any changes to that outside area.
So it's your testimony today that you couldn't make any changes to the outside light area to move a switch?
I mean, anytime we had to, like, for the guardrails, for example, we had to call Kermit. And so we did do something with the light inside, but I mean, we couldn't start changing a bunch of stuff under the terms of our lease. Like, we had to call and ask Kermit. And, you know, the light, we did install a switch inside the building that lets us, like, turn on the light that is illuminating outside, but it's on the inside.
But just to be clear, before Mr. Gilmore fell, you had not moved the light switch either inside or outside of the building.
I don't believe so.
So when Jordan was doing what he was told to do and went to the dumpster to smoke, there was no light on outside.
I don't know if the light was on or not when he did go outside.
There was no railing on the platform?
No, there wasn't.
And Jordan, in fact, said the same thing that your employees did 10 years ago. You heard him during his direct, that if the lights would have been on, he probably wouldn't have fallen. Isn't that right?
Well, I mean, sure, I guess. He also could have done some other things too, but yeah.
And you're
briefly, I'm going to object and ask to strike the portion of Mr. Hobbs' question, which said, like the incident in 2010, that refers to that redacted portion of Exhibit 14, or in whatever year it was. I apologize.
Yeah, I'm gonna, for actually two things, for that and for your reference to a question on direct that was objected to, that objection was sustained, that answer was never given. Or at the very least was ordered excluded. So I'm going to instruct the jury to disregard both of those comments and ask you to please keep in mind the rulings of the court as we move forward.
Yes, Your Honor. You heard earlier that your manager's advice for Mr. Jordan was to quit smoking.
Yes. Yeah.
And again, to not go outside without the light being on.
Yeah, one of the things, sure.
No further questions at this time, Your Honor.
Any redirect?
Yes, Your Honor. And permission for my co-counsel to republish what was entered as Exhibit 13 on direct.
Sure.
Now, as Mr. Meinkoth does that, Ms. Geller, I want to turn from the talk of use that Mr. Hobbs was very focused on to the talk of control of that back area. In this document, I'm going to go ahead and refer you to the portion of this document beginning at the first sentence. Can you read that first sentence of the document for us?
Sure. Per the terms of our lease, we are requesting that Kermit Realty Group LLC as landlord remove the railing from the steps in the landing area behind our premises immediately outside of the emergency exit doors at the rear of the building.
So thank you, Mr. Meinkoth. We can take that down. So Ms. Geller, you referred to that area as behind your premises. So did you have control of that area?
I mean, we did, but we didn't have the authority to just rip off the guardrail.
Right. So if you had wanted to make any improvements or permanent changes there, could you do that without Kermit's approval?
No, we couldn't. We had to ask them.
No further questions, Your Honor.
Very well. I'm sorry, I'm blanking. Ms. Geller, sorry. You're excused. Thank you.
Thanks.
Any other witnesses?
Yes, Your Honor. At this time, we call Mr. Perry Hayden to the stand by way of deposition.
Very well.
Give my co-chair a second to join us. There we go. Beginning on page 1, line 5. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Perry Hayden.
Mr. Hayden, where do you live?
I live in Austin, Texas.
And what do you do for a living?
I am a compliance, safety, and health officer with the Occupational Safety and Health Administration.
And what do you do at OSHA as a compliance, safety, and health officer?
I am one of the people from OSHA that goes out and inspects workplaces on a regular basis to see if that workplace is in compliance with OSHA standards.
And how long have you worked for OSHA?
Since I got out of school. So at this point, that's about 13 years.
And I apologize, Your Honor, for the record, I had moved to page 3, line 16. Now moving to line 19. And over that time, how many inspections have you conducted?
Oh man, hundreds, thousands. I mean, the answer is a lot. It's basically my entire job. So I'm always out on the road inspecting somewhere. It's an everyday thing.
Moving to page 5, line 1. Are you being paid by anyone for your time here today?
Nope.
Line 6. All right, Mr. Hayden, how are you involved in this case?
Well, I conducted an inspection at the Chimes department store in Waco back in 2018. So I assume that's why I'm here.
And Mr. Hayden, I'm showing you what has been marked as Exhibit 36. Do you recognize this?
Yes, this is my report from my 2018 inspection of the Chimes department store.
And is Exhibit 36 a true and correct copy of the report regarding your 2018 inspection of the Chimes department store?
Yes, it is.
And at this time, we move Exhibit 36 into evidence.
Any objections?
No objections, Your Honor.
Exhibit 36 is admitted.
Moving to page 6, line 8. Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
Did you inspect the area behind the store where there's a little landing area and some steps?
Yes, I did.
When you went out there, what did you notice about the steps and that landing area?
Well, at first, I was a bit alarmed because there was some pretty obvious issues.
Like what?
Well, there were stairs and a landing area, but there were no guardrails anywhere. Plus, the concrete on the edges of those steps and that landing were cracked and eroding away.
Line 9 on page 7. If there were such obvious safety issues, why didn't you issue any citations?
As I said, I got pretty alarmed. So I asked the manager that was walking around with me during the inspection about the fact that there were no guardrails and about the cracked concrete. The manager told me that there used to be guardrails, but they were removed because Chimes used that landing area as a loading dock.
Why does that matter?
Because loading docks don't have to have guardrails.
And how do you know that?
Because OSHA says so.
Page 8, line 20. Is there any OSHA regulation that specifically discusses loading docks?
Yes, 1910.28B13 clearly states that guardrails aren't required on loading decks because they aren't feasible. You can't very well load something onto a dock with a bar in your way.
Page 9, line 1. Have you had a chance to review the deposition of Kelly Danes?
Yes, I have.
Well, what do you have to say about all of the OSHA regulations that Kelly Danes testified were violated by the defendant because of the condition of the landing area and back of the store?
I'm sure Miss Danes is a very nice person, but they're just reading those regulations too broadly. None of them deal with loading docks, which is what Chimes was using this area as. This wasn't just a stairwell or just a landing area at the top of a stairwell. This was a loading dock, and the provisions cited by Kelly Danes don't deal with loading docks.
And was this area behind the store exclusively used as a loading dock?
No, it is my understanding employees also went out there to throw trash in the dumpster and to take breaks. And it is certainly possible that employees went out there and did other things as well, but I don't think that matters.
Why not?
Well, just because an employee goes out and sits on the edge of a loading dock and eats a sandwich doesn't make that loading dock a diner. The key thing here is that Chimes used this area as a loading dock. That's what matters.
No further questions, Your Honor.
Okay. Anything you'd like to add, Mr. Hobbs?
Yes, Your Honor. Starting on page 6, line 4, how do you determine if a condition is dangerous?
Well, if a condition on the premises doesn't comply with the standards under the OSHA regulations, then it would be dangerous, and that would necessitate a citation.
Moving to line 22 on that same page, when you went out there, what did you notice about the steps and that landing area?
Well, at first I was a bit alarmed because there were some pretty obvious issues.
Like what?
Someone with half as much experience as me could look at that and see some pretty obvious problems.
Moving now.
Quickly, Your Honor, just a brief objection. It appears the witness's audio is not on, so I'm guessing they're in the same room and it's coming from next door, but I think it would be helpful for us to hear a little bit better if the plaintiff's mic was unmuted. Or sorry, not the plaintiff's witness mic was unmuted.
Your Honor, I can move the microphone we have in this room around to make sure that everyone is being picked up.
I think we're hearing it just fine.
Okay. Moving now to page 9, line 23. Ms. Hayden, I'm showing you what has been marked as Exhibit 38. Do you recognize this?
Yes, this is an email that I received from one of my superiors in May 2019.
Do you disagree with the assessment of your boss in this email?
No, I don't. I'm fairly conservative when it comes to issuing citations. So maybe I'm a little bit more lenient than other inspectors.
Moving now to page 11, line 4. Do you have any opinion about who was in control of that area behind the Chimes, whether it was Chimes or the landlord?
Nope. That's way outside my bailiwick. I mean, it certainly seemed to me like it was Chimes's property, or at least they were in control of it based on everything they told me.
Moving to line 18 on that same page. Did you notice a light out there when you were doing your inspection?
I did. You'll see it noted in my report.
Did you ask the manager about those lights?
I did. Like, you can see it in my report.
And what did the manager say?
The manager told me that they always turn the light on when somebody goes out back at night. So that seemed good enough for me.
Your Honor, I have no further questions at this time.
Okay. Are we ready for closings, or do y'all want a few minutes break prior to closings?
Can we maybe a 5 to 7 minute recess, Your Honor?
All right, let's keep it to, well, let's all give you guys 8 minutes to make it round. Be back here at noon so we can roll into closings.
Yes, Your Honor.
Your Honor, is it okay if we do some tech checks during this break?
Go nuts.
Thank you. Mr. Minecoth, can you verify everything looks good and sounds good here?
I can see and hear you just fine.
Great, thank you. I am not muted yet. Hold on.
Everyone, I apologize. Right as we got off, I got a phone call, one of those like tech emergencies. As the young guy in the firm, I get to fix it. So get excited about that life. Do we have all of our scoring judges here?
Yep.
See, 2, 3. Miss Stapley, are you here by any chance?
Yes, here and on mute. Apologies.
Awesome. Nope, we're good to go. All right, real quick, I'm going to give you all a time check. Y'all didn't ask for one, but I'm going to give it to you anyways. Plaintiff, you have 13 minutes and 17 seconds remaining. Defendant, you have 24 minutes and 47 seconds remaining. And you may begin at your convenience.
Yes, Your Honor. Before I begin my closing statements, I would just ask to reserve any remaining time that I have of those 13 minutes.
It is so reserved.
Yes, Your Honor. Your Honor, opposing counsel, members of the jury. Dark, derailed, deregulated, and dangerous. That's why you're here today, members of the jury, and that's what you've heard throughout today's testimony. That in January of 2019, when Jordan Gilmore was where he was supposed to be, where he was told to go by his employer, he was injured because of the lack of railing, the lack of lighting, and the fact that the plaintiff or the defendant knew about those issues. In fact, I wrote down the words of Ms. Nickel during her opening statements. Any reasonable person would have known that those stairs were dangerous. Members of the jury, that's exactly what we've heard throughout today's testimony. But this story didn't begin in 2019. It didn't even begin in 2010. It began all the way back in 2005. When the defendant's store first moved to their current location here in Waco. You heard earlier today about that statement that was given to them, that email between the landlord and the tenant. Subject line, loading dock. We need this done ASAP. Remove the rail. It makes it impossible for us to move supplies in and out. Now, throughout today's case, the defense has done exactly what I told you they were going to do. They've attempted to distract you with lease agreements. They've attempted to distract you with who was actually in control of the premises. Well, let's walk through those regulations and walk through what the law requires and the jury instructions you're going to receive in a couple of moments when Judge Altman charges you as a members of the jury to reach a verdict in today's case. You heard earlier today during the testimony of Kelly Danes that there are a number of regulations that apply in this jurisdiction, both under OSHA and under the International Building Code. You heard today that OSHA applies in any location where workers are being employed. You heard that for the OSHA representative himself whenever he was in court today during that deposition testimony that was given. You heard that representative tell you that these laws don't apply to loading docks. Well, let's look at what those laws actually say. And you, the members of our jury, can determine what you believe the law says. You see, you're going to have the opportunity to look at what the law says about loading docks. That same law that the OSHA representative would have you believe says that you don't need to have any guardrails around a loading dock. Well, look very carefully at what is before you right now. You'll see that that exception only applies if 3 criteria are met. They have to meet all 3 of them. Otherwise, they have to have guardrails in place. The first criteria requires that any employee that's operating in that area must be conducting the activity for which the guardrail was removed. The second criteria requires that only authorized personnel are allowed to use that space. And the final criteria requires that training be applied and appropriate to the individuals who are going to be operating that loading dock. Members of the jury, starting with that first element, we've heard that that rail was gone regardless of whether there was a delivery or not. In fact, you heard today that at 7 p.m., when the store was about to close at 8, that is when Jordan Gilmore was injured. You heard today that there was no delivery going on at that time. Jordan was going out for a smoke, but that railing was not there. So they failed to meet the very first prong of what the OSHA representative wants you to believe is the requirement. And we know why that OSHA representative thinks that way. You heard during his cross-examination by deposition that he might be a little bit more lenient. He might let things slide. He may not issue as many citations as he should. Members of the jury, that's exactly why he was willing to overlook clear and obvious and what he considered alarming discrepancies and deteriorations of that staircase. Now, the defense today has also attempted to convince you that they didn't have control over the space. Members of the jury, when Ms. Nichols, on her redirect of the defendant herself, asked the defendant if they had control, she said, "I mean, we did." Members of the jury, you're going to have the opportunity to look at 2 different prongs of how control can be established. You're going to have the opportunity to see that one way that control can be established is by contract, and the other way that control can be established is by actual control of the space. I don't know anything other than actual control, members of the jury, when the defendant herself says, "I mean, we did. We controlled it. It was our space." They used it for their trash cans. They used it for their smoke breaks. They used it for loading and unloading throughout the day. You heard that there were multiple trips taken per day out there. Jordan himself told you that he was out there 20 times a week. Members of the jury, that is control. I would imagine that in a couple moments, Ms. Nichols is going to come up here and she's going to show you that map. She's going to show you the cross hatching on it, and she's going to show you where that X is. But members of the jury, when you go back into the jury room, you're going to be able to read the instructions. And you're going to see that an employer is responsible not only for the space where their employees work, but any surrounding areas. It doesn't matter whether they asked the company that owns the property to take down that railing. They could have asked them to dig a 100-foot hole in the back. That still makes them responsible for protecting their workers around that hole. We don't just get to walk into a bar and sign a document that says, oh, bartender, if I leave here today and I get into an accident after you serve me drinks, well, I won't sue you. No, you won't be responsible. Members of the jury, that's not how logic works. That's not how our common sense works. So in a few moments, when you go back into the jury room, you're going to be confronted with a jury sheet. It's going to ask you a couple of questions. It's going to ask you whether or not you believe that the defendant acted negligently in today's case. And you're going to be able to answer yes, that the defendant's store did in fact act negligently by violating OSHA regulations, by having active control over that space. And despite the distractions they've tried to put before you today, despite the contract they want you to believe, makes them completely not liable today. Members of the jury, that's not how common sense works. That's not how the law works. So you're going to be able to mark no. You're going to be able to mark no next to that second question. But in the event that you believe both parties had some culpability in today's case, you're going to move on to a second question. And it's going to ask you to assign percentages of liability. If you've heard nothing else today, members of the jury, you know that when Chimes Department Store had control over that space, they were 100% liable for the injuries that happened to their employees while they were in that space. Dark, derailed, deregulated, and dangerous. Find the defendant, Chimes Department Store, liable. Thank you.
Any closed defense?
Yes, just one moment. I had a little tech hiccup while I was waiting, so 1 second. I apologize, Your Honor.
No problem.
The joys of Zoom trials. Okay, thank you for your patience. Okay. Members of the jury, Kermit was in control. Use is not control. Now, members of the jury, Mr. Hobbs just got up here and put a statute in front of you and talked about some regulations, but I want to be very clear with you. From the very beginning, you are not deciding this case based on those laws. You are not deciding whether the defendant Chimes violated OSHA regulations. That's not what you're here to decide. So let's look at the law that you will see in your jury instructions that you will be tasked with deciding today. And I want to start with this issue of ownership. Now, to be clear, in your jury instructions, it will tell you that in order for Chimes or Kermit to be found guilty of negligence, they needed to be in control of the area at issue. They needed to be in control. It does not say they needed to use. It does not say they needed to keep clean. It says they needed to be in control. That is the issue in today's case, members of the jury, because before we can even reach the issues of negligence, we have to handle this problem of control. What you heard today was that the property where the plaintiff was injured was in control of Kermit Realty, the property owner. That stairway out back was in their control. Now, Mr. Hobbs just said I'd get up here and show you that lease agreement and those crosshatches. Let me let you in on a secret. I don't need to show you any of that. You'll have that in your jury deliberations. Don't get me wrong. They will be there. They've been entered into evidence. And certainly that is evidence that Kermit Realty had control of this property. But it's not the most important evidence. Members of the jury, the actions of these two groups are what are the most important evidence today of who had control. Again, use is not control. I'm certainly using this office space in my law school today, but I'm pretty positive our administration would tell me that I definitely do not have control over this space. I certainly couldn't take down the doors, start making permanent changes. Those are two different things. Members of the jury, use is not control. So look at the areas and the ways the parties acted when it came to permanent changes to this property. When that guardrail was to be removed, when Chimes determined the guardrail needed to be removed, they didn't remove them themselves. They didn't remove that guardrail. What Ms. Geller told you today was they couldn't possibly have done that. And when I asked her why, she said, well, we don't have control over that. Members of the jury, look at how the parties acted. Certainly, the lease, the photos, the crosshatches, that's all relevant evidence, and you will have that in your jury room to deliberate with. But more importantly, look at the actions of the parties today. Look at who exercised ownership. I told you to pay close attention to Kermit Realty's actions here. And that's because no landlord would incur the cost and the time and the resources to go remove a guardrail from a concrete stair landing unless they had to. Use is not control. So members of the jury, that leaves you now with the question of negligence. Now, to be clear, as we've showed you, Chimes did not have control of that area. Even if they used it, they did not have control. Thus, they cannot be found negligent in this case because that guardrail, that concrete, those were not things in their control. Members of the jury, let's turn then to Kermit and whether they can be found negligent today. You see, your jury instructions will contain these provisions. It'll tell you that in order for Kermit to be found liable of negligence, they need to have posed an unreasonable risk of harm. They needed to have reasonably or should have reasonably known of the dangers that they posed. And they needed to have failed to exercise ordinary care. So let's talk about each of those in turn. Starting with the unreasonable risk of harm. Members of the jury, I told you at the start of this trial, and Mr. Hobbs reiterated for me in his closing that those stairs, well, the danger of those stairs could be seen from far away. It's not disputed today that those stairs were in a dangerous condition. The concrete was falling apart. There was no guardrail. That was an unreasonable risk of harm that Kermit created. But I want to focus in your attention because Mr. Hobbs talked about the light, the guardrail, the concrete, all these elements. But I want to turn your attention to what actually caused the injury today. Because you heard on the cross-examination, of Mr. Gilmore, that he had been on that landing with no guardrail over 10,000 times. Members of the jury, that's no small number. I think after I've been someplace 10,000 times, I really get to know the landscape. I know where I need to turn to step. I know where the edge is. I know where the side is. I know where the wall is. I know that area. Why? Because I've been there 10,000 times. And we heard a lot of discussion about this light, right? Whether the light, it was dark, that was the issue. But Mr. Gilmore testified that it was a regular occurrence, that he was out there at night without a light. That's not what made this 10,401st trip outside different. It's not the light. So what made this trip different? What caused him to fall on this occasion when he hadn't have fallen on any of the prior 10,000 trips? Well, let's take a look. Members of the jury, these were two of the exhibits admitted into evidence today, the diagram and the photos of the stairs. What we pointed out to you and what Mr. Gilmore testified to is on this top step, well, there was a chunk of concrete missing, a step onto a landing that he had done 10,000 times before, and yet this time something happened and his foot slipped. So ask yourself, what factor changed? Well, it was the eroding concrete. Members of the jury, it was the concrete that had continued to deteriorate on that step over time, so that the step that Mr. Gilmore had taken 10,000 other times, all of a sudden was different. He slipped. That is what was different on this 10,401st occasion, unlike every other occasion before. That is why this concrete is such an important issue today. Members of the jury, this concrete, this structural component in a common area of the building, that was under Kermit's control. That was the unreasonable risk of harm that Kermit posed. And if you're still not convinced about the light issue, just remember when you go to deliberations, Gilmore didn't trip on a light. So let's talk next about whether Kermit reasonably should have been aware of the danger they posed. And this one's simple, members of the jury, because both parties agree. This was a dangerous condition that was easily recognizable. Kermit Realty, in their regular maintenance and inspection of this property, should have seen this. Even if they didn't, they certainly should have. It was unreasonable for them not to. So let's talk about that last element. Whether they failed to exercise ordinary care and make repairs. And again, members of the jury, we agree with plaintiffs. This was a situation that should have been resolved. This was a situation that a reasonable person acting in ordinary care would have fixed. And under their lease obligations, they were required to. They were required to maintain a safe common area for their tenants, which they failed to do. Members of the jury, with that in mind, you're going to be given this first page of the jury deliberation form. This is the same one that Mr. Hobbs just told you, but I want to be clear. Unless you find that Chimes Department Store had control over that landing, had control over that concrete, that it was their job to fix it, you cannot find Chimes negligent in today's case. That is the standard of law you're applying. So we ask that you state no. When it comes to Kermit Realty, we've shown you that they've met those elements of negligence that I showed you. And in fact, plaintiff's counsel did a lot of the work for us in arguing that. These stairs, that concrete, posed an unreasonable risk of harm. A reasonable person would have been aware of it and knew of that danger, and they failed to exercise ordinary care. The only problem is, members of the jury, it's not the men and women of Chimes Department Store whose job it was to fix that. It was Kermit Realty, the property owner. That's why when you get to the phase of assigning liability, we ask that you assign 100% of the liability to Kermit Realty Group, because they exercised control and they were negligent in this case. Members of the jury, we agree that this was about the failure of a corporation. That is why we're here today, is because a corporation failed to protect the people on their property. That corporation was just not Chimes Department Store. It was not the family-run business. It was Kermit Realty LLC. The property owners who signed a lease, who made a promise to hold up their end of the bargain, to maintain and inspect and keep safe the areas that they agreed to in that lease, the areas that they had exercised control over in removing that guardrail. Members of the jury, Kermit was in control. Thank you.
Rebuttal?
Yes, Your Honor. Before I begin, do we have a time check on how much time I have left?
4 minutes and 9 seconds.
Yes, Your Honor. Members of the jury, Ms. Nickel is right. You are here to decide who had control of that space and who was negligent with that space. And there's a couple of questions that you'll be able to ask whenever you go back into the jury room. Who was it that asked for the railing to be removed? That was Chimes. Who was it that didn't fix the light until after multiple people had injuries? That was Chimes. Members of the jury, we've met our burden today to prove to you by a preponderance of the evidence, that is, that it's more likely than not that it wasn't the real estate company, the owner of the land, who was responsible for that space, who exercised ownership over that space. Chimes used the space. Chimes had control of the space. Chimes was responsible for ensuring the safety of their employees. Because of that, I'm confident when you're confronted with that first jury question, when you go back to the jury room today, you will be able to answer yes to that first question, that it was in fact the defendant, Chimes Department Store, who was liable. And that the real estate company, they had nothing to do with how Chimes upkept that space, with how Chimes used that space, with how Chimes controlled that space. Find Chimes Department Store liable. Thank you.
All right. I think judges just need to fill out their ballots and get them to the folks running the competition. And I believe they have, I'm going to double check on feedback and how they want to do that before we roll into that. But in the meantime, the scoring judges could please fill out your ballots. Thank you. All right, if everybody could come on video, I have been asked to start us on feedback, as in like get us all rolling on feedback. And I have been asked to reiterate short feedback, like one thing per side, and go from there. So would someone like to start us off?
Sure, I can go real quick.
Okay.
Sure. Hi, competitors. Congratulations for making the tournament. Excellent job. This tournament is unique in that everybody here is good. The scoring is always by razor thin margins. You both did an excellent job. So I'll just be super quick. My name is Steven Lopez. I'm a plaintiff's attorney in San Antonio. Competed a lot, coached a lot, and judged a ton. So great job. You're both excellent advocates. Mr. Hobbs, my critique and suggestion for you as you advance in the rounds is just a little more technical and a little tweak. I love your opening. I think overall you're an amazing storyteller. When you started reading from that email to me in the opening, it kind of pulled me out. It was a little too technical language and it was a little too long. I think your gift of storytelling is better served if you just tell us what's in that email and hold it up. You'll see an email. It's going to say this. Bring yourself to that instead of reading from it, because you're off to a good start. And then immediately at the beginning of that opening, I was kind of sucked out by the verbatim reading of such a long email. One tiny little tweak. Other than that, great. You did an excellent job. You don't need to hear any more from me. Miss Nickel, excellent job as well. I think you have the harder side of this case. I think the evidence is there. I think logically your case is sound. It's just never sexy to be arguing control, right? In a case like this. So one little tweak on your objections. I thought you were excellent on your objections, and you knew the law cold. One time the judge asked you if you were objecting, and you said no. Well, maybe I could object to this, but I'm not going to, right? That was just kind of like a show off remark. I know that was like, it's hard to do that when you're competing, right? Because you're a competitor and you want to show everybody that you know your stuff. Make the objection or don't, right? It's hard to resist. And I think I probably would have gone the way you did too, but just watch that. But in general, the bigger critique and that I want you to focus on going forward as you advance is control is the issue, and you've got the law on your side, and you kept hammering control. I would like more weaved into your story and into your close. Why, right? You're telling the jury you have to find no because they're in control, but why is it right? Where's the fairness? Where's the justice in that, right? I need a little more connection to morality, because right now it seems to me that your case is technically correct on the law, but I need more of why is that fair? Why is that correct? Why was it unjust to hold Chimes liable? And that's my critique. Excellent job, both of you.
So I guess we're gonna order Mr. Goins. You want to go next? You're next on the list. Sorry.
Oh, yeah, sure. So Tim Goins, I'm a Lieutenant Colonel JAG in the United States Air Force. I'm also a professor at the United States Air Force Academy. I coached their mock trial. I competed in a mock trial. I was on the team with Crystal. So it's been a while. So any event, as far as feedback, I'll echo the same thing. You guys did a great job, both very prepared, especially with the reduced amount of prep time you have. For Matt or Matthew, Mr. Hobbs, the thing I would probably focus on for future rounds that I noticed was, this is probably me being particular, but I thought for your direct examination, you could have sort of receded a little bit. You sort of dominated the direct, and I felt like your witness didn't get as much opportunity to talk as I would have liked, especially being the plaintiff in the case. I really would like to see that person be front and center. And then for Ms. Nickel, is it Nickel or Nichols?
Nickel, like the coin.
Nickel, just one. Okay.
Just one.
Yeah, for you, I tended to agree with Mr. Lopez when it all came down to control. I would have probably liked maybe a little bit more of explanation of that in the opening, just so as a juror, I could frame it a bit better. I know, once again, it's not sexy, but I think it was sort of what you needed to do, and then go whole hog into that. And as he said, weave it. So I just echo what he said. So.
Okay.
I can go next.
Yep.
Maybe I'm the only one left, but in any event.
You're next on the list anyway, so it's your turn.
So Crystal Stapley, this was great. I echo everything everyone has said so far. I'm searching for constructive criticism, so realize that I'm getting awfully nitpicky here. Mr. Hobbs, your opening I thought was really excellent. Great organization, great storyline. Good job pausing for emphasis in certain places. The constructive criticism, and again, this is getting very nitpicky. When you were getting into the flow, you had a lot of sort of maybe choppiness, or you sort of emphasized certain words in a way that seemed pointed and emphasized as opposed to conversational. That's really good. There's a place for that, but think of it like highlighting in your textbook, right? If you highlight too much in the textbook, the highlighting doesn't serve its purpose. So again, it was an excellent opening. That is very nitpicky, but I'm supposed to give criticism, so there it is. Also, great job reacting to an objection. I'm sorry I didn't write down exactly which one, but I did make a note. I think maybe the judge was trying to give you an opening to go back to the witness and lay the predicate so that you could get that evidence in. Again, in the moment, you're in adrenaline. You reacted well, but if keep that in mind, because it sometimes is worth thinking, could I lay the predicate to go ahead and get this evidence in? Miss Nickel, one nickel, not plural nickels. On your opening, again, excellent across the board. On your opening, I thought it was great. Going forward in the competition, I would consider reworking it so that you, instead of starting with sort of the injury, start by having us sympathize with your small business client, your family business client, and have us sort of get emotionally attached to your client before you start talking about this terrible thing that happened and how it was somebody else's fault. You got all of that in there, but I would have reworked the order. Great job on objections. You did a great job making sure that, one of your objections in particular was preserved, which in the courtroom in real life is important. Good job in your closing argument and the analogy with the law school. I'm in the law school, but I don't have control of the law school. I can't take off the door. Again, you had the harder factual case, and that is, we realize that is beyond the competitor's control. You both did a great job. Judge Altman, forgive me for not sticking to the one item.
That's all right. You were pretty quick. Mr. Gray.
Hello, greetings to everyone. Very hard decision on the ballot, so I won't even go into that. I will try to stay quick. Mr. Hobbs, consider this is similar to another going forward, using that email in evidence when you're examining the witness. You basically did a long read and then I read that correctly, didn't I? Rather than that, there's a lot of ground that you can argue the email to the jury as you're using it. So, read the statement and then use the witness to argue to the jury what that statement means, not just what it says. A clearer example of that was the other document you used about, don't go out in the dark and needs to be well lighted. When you sort of half argued it and you said, so your manager said, fill in the blank, as opposed to, so your manager knew it was dark out there. Your manager knew it needed a light, and yet it didn't have a light, did it? So taking a statement and then using your cross to argue to the jury, not only what that statement says, but what it means. All right, I just didn't introduce myself at all. I just barged in there. I'm Kendall Gray. I was in big law forever. I was on the Baylor mock trial team back when Jerry Powell was a young man and Herbert Walker Bush was president. And now I've escaped big law and I teach legal writing at Duke Law School. So enough about me. Ms. Nickel, a couple of really quick things. Factually, I'm not sure I buy factually that the concrete on the steps degrades fast enough, just as a matter of fact, that it is, absent some other testimony that maybe I just missed, that between trip 999 and 10,000, it's different, and that's why he slipped. So I'm not sure I buy that factually. And then one really, again, nitpicky stuff, and I might have only recognized this because of the Zoom format, but jurors notice really weird things too. And I almost hesitate to bring it up because it's a potentially unfair criticism of a female advocate, but then jurors are unfair too. You're playing to an unfair audience in a jury. There was a bigger disparity in your persona between when you were on and arguing and when you were off. When you were on and arguing, you were awesome, forceful, in control of the situation, appropriately forceful and pleasant at the same time. When you were off, you looked a little bit more like focused, but worried and concerned, which is like, it's sort of like, but the jury can watch too when you're not on. And so trying to keep that on and off persona to be more closely related to each other. And that's all I got.
So I'm Mark Altman. I did the JAG thing for a bit, and now own with another person, a law firm here in Waco, doing litigation stuff. I coach mock trial, so I am fairly commonly do the whole criticism thing. So, but I will keep it short this time. So I will give one thing for both of you guys just to make it fast. The biggest thing that I try to teach folks is you have to have credibility for everything you do in the courtroom, right? And that's credibility with the judge, credibility with the jury, credibility with the witnesses, whatever. And I like to think credibility kind of like a bank account, right? As you do smart things, as you do good things, as you do honest things, as you do insert adjective thing, you bank that credibility. And then when you have to do the big thing, when you have to say the kind of out there thing, when you have to shut a witness down who's being tough or whatever, right? When you have to do the thing that people kind of want to hold against you, you draw against that credibility, right? And you better hope you banked enough to make it work. Okay. And that starts from the moment you walk into the courtroom. It can be how you sit, how you stand, how you talk, how you sound when you're arguing versus when you're sitting there, whether or not the judge finds out during your meet and confer, you were fully, transparent and working with the other side in order to do a proper meet and confer or not. It could be everything, right? It could be your tone of voice, whatever. And I would say both of y'all at different points either tried to draw on something where you hadn't yet built the credibility to do that, in my opinion, or you did something that damaged that, so it prevented you later on from using it, right? And so I think one of the things that I can use as an example for that is, Ms. Nickel, your whole, yeah, we told them to take away the rail and they did it, but we don't have control, so it's not our fault, right? We told them to do it and they did it, but it's not our fault because they did it, right? It's their fault. That's a big ask, in my opinion, right? To get a jury to be like, okay, yeah, sure, we'll blame them, even though you said to do it. That's a really big ask, and you've got to have some credibility. One of the ways you can build that credibility, though, is by explaining why it was necessary to take that rail away, right? Make it clear that you didn't ask for a bad thing. You asked for a good thing, right? Hammer that loading dock thing. It's necessary to have the rail gone to be a loading dock. You asked for a good thing that had some necessary negatives to it. They did it, and they didn't do the other stuff necessary to make our asks safe, right? We're not bad guys. Because then you immediately rolled from that into find what justice demands. And I'm like, I don't know. It sounds like justice demands hammering your client, right? And then Mr. Hobbs, anything for you, right? There's a few times there, especially you did a great job of witnesses, you did a great job in argument. The way you argued evidence, I think, was the biggest problem for you in what I'm talking about, right? For instance, your whole motion in limine was don't talk about this whole complaint thing. It got granted because the other side agreed to it. And then in opening, you talked about whether or not your client filed a complaint. In direct, you talked about whether or not your client filed a complaint. I mean, it was over 5 minutes of time on that. Had Ms. Nickel wanted to, and she wanted all of a sudden to get into that just to prove the point, in my belief, you completely opened the door to the motion you argued, right? So I'm sitting here going, okay, why did we spend all that time of my life at the beginning of this talking about this motion if you didn't want it in the first place, right? That kind of stuff can make it difficult later on when we had some of those more kind of out there evidence discussions for me to want to believe you at face value, because you showed me earlier that I couldn't believe you at face value, right? So that's what I'm talking about. I think if you guys were to hammer that, I will say you guys did a really, really good job, though, throughout this entire thing. Killer job. Now finish this competition strong and go out into the real world and kick, people's rears. So I did
Thank
get
you
the
all so
thumbs up, though, that all our ballots were accepted and none of us messed it up, which might be a miracle. But I appreciate y'all's time, and have a wonderful day.
Thank you all
Thank
so
you all
much.
Yeah, and thank you, Matthew. That was a great round.
Yeah, thank you, Ms. Nickel. It was really fun.
Thank you. Great job.
She just
Mr. Meingoth, if you're here, can we do a quick tech check while we have a second?
Sure thing.
Great. We good?
Looks good.
Great. Thank you.
All right. Hello, everyone. My name is Judge Yelverton, and I will be your presiding judge for today's trial. Wanted to check first off and make sure we have everyone present that we need in order to get started. Counsel, I think we have Ms. Nickel and
Yes.
Ms. Dogue. Am I pronouncing your name correctly?
It's Doig, Your Honor, but I know it's a tough one and I'll answer to anything close.
I think I can manage Doig. All right, so we have counsel. Counsel, do you both have your second chairs present?
Yes, Your Honor.
Yes, Your Honor.
And do we have the witnesses present?
I believe they're sharing a computer if it was the same as this morning, in which case, yep, they're all there.
Both witnesses we're here.
Perfect. And I think we also have 4 jurors, Mr. Steed, Mr. Jones, Ms. Sheridan, and Mr. Alexander. Is that correct?
Yes, Your Honor.
All right. I think
Yes.
that's all we need to get started. Anything else we need to take up before we proceed to pretrial matters?
Your Honor, may we make appearances on the record?
Yes, that'd be helpful. Thank you.
Good afternoon, Your Honor. My name is Lauren Doig, and I'm here with my co-counsel, Aaron Friedman.
Good afternoon, Your Honor.
We represent the defendant, Chimes Department Store. We do have one stipulation and a few procedural matters for Your Honor after opposing counsels had the opportunity to introduce themselves.
Thank you. Plaintiff's counsel?
Yes, Your Honor. Rebecca Nickel on behalf of the plaintiff, Jordan Gilmore, along with my co-chair.
Okay, perfect. Does the plaintiff have any housekeeping matters to take up prior to opening statements?
Yes, Your Honor. We do have some exhibits that for the sake of efficiency, we have agreed with opposing counsel to admit into evidence now.
Okay. What are those exhibits?
Yes, Your Honor. Those exhibits are 3, 4, 5, and then 11, 19, and 36. And Ms. Doig, please correct me if I missed any or said
That's what
anything.
I have as well.
Great.
So 3, 4, 5, 11, did you say 19?
19 and 36.
And 36. All right, hearing no objection, those 6 exhibits will be pre-admitted.
Yes, Your Honor. And just to put the court on notice, I do intend to use Exhibit 19 in opening, and I do modify it slightly, just dimming the photo. I've shown this to opposing counsel, and it is my understanding that there's no objection to me using that in opening.
Ms. Doig, is that correct?
That's correct, Your Honor.
Okay, perfect. What else do we have in the nature of housekeeping matters from the plaintiff?
Yes, Your Honor, just one final one. We wanted to ensure that the court was okay with the method of admitting exhibits that we have found is most effective in this fun format, which is to have the witnesses refer to the exhibits in their own packet, lay the foundation, admit the evidence, and then go ahead and ask your permission to publish to the jury.
As long as the record is clear, you can do it however you want.
Thank you, Your Honor. And we do have some other stipulations, but they are more substantive motions, so we can address that after Ms. Doig has had a chance to do any pretrial matters.
Okay. Ms. Doig, what housekeeping matters do you have?
No other housekeeping matters, Your Honor. I think Ms. Nickel covered it.
Perfect. Then plaintiff, we can take up your substantive motion.
Yes, Your Honor. So the plaintiff would like to clarify first, Your Honor, one stipulation that we've reached, and then we do have a substantive motion. But for some context, this case is about an event on January 23rd, 2019, when Mr. Gilmore, on a break at his place of employment, slipped and fell. Now, this case is about the hazards that the defendant corporation created in that context. Your Honor, moving to the first stipulation we have reached, we discussed with Ms. Doig the fact that we will not elicit testimony today that there was a light switch installed by the defendant corporation after the injury, in fact, occurred in 2019, as that would be a subsequent remedial measure. But we also agreed to stipulate then under that basis that it was feasible for the defendant to have installed such a light switch.
Okay. Ms. Doig, did Ms. Nichols correctly state your stipulation?
That's correct, Your Honor. We won't be disputing feasibility.
Okay. What else, Ms. Nichols?
Yes, Your Honor. For our second motion, we have discussed this with opposing counsel, but I think we need Your Honor's clarity in terms of where the line is with this evidence. So today we have a witness coming to speak, Miss Reese Geller. I believe it's a miss this afternoon, but correct me if I'm wrong, Ms. Doig. And she is the owner of the defendant corporation. Now, she is in no means a property law expert or anything of the sort. So we would object to her testifying as to her interpretations of a lease at issue in today's case between the defendant Chimes and the property owner Kermit Realty pursuant to 701, 702, 401, and 403. Now, it's our understanding Ms. Doig doesn't intend to get into expert testimony regarding her interpretations in terms of what they actually meant, but we would still find that her interpretations therefore are then irrelevant if they're simply her interpretations, as they don't go to a fact of consequence in today's case and would mislead the jury under 403 as to her role as a lay witness. Ms. Geller is no more qualified to interpret the legal terms in this lease than anyone else on the jury.
Okay. Ms. Doig, would you like to respond to that?
Yes, Your Honor. Like opposing counsel mentioned, we're not going to be offering this witness as an expert in property law. However, her opinion and her interpretation of the lease that she was a party to and that she signed that corresponded to an area that's in dispute today is relevant and does go to an ultimate issue in today's case. Today, because it's a negligence case, the jury will be asked to evaluate whether the defendant used ordinary care in maintaining their property, which, as Your Honor knows, is the care that other companies in similar circumstances would have used. Therefore, the defendant's interpretation of a lease, understanding what areas she was responsible to maintain and what areas she was not responsible to maintain, and the actions she took as a result of her interpretation of the lease are relevant and go to that third element of a negligence claim.
Okay.
Brief response, Your Honor, just for clarity.
I'll give you the opportunity to respond. Sure.
Yeah, Ms. Geller, to be clear, did not sign this lease. Her father did at the time. She was simply present and around at the time the lease was made. So this would not go to whether they exercised ordinary care. That's a question for the jury. Instead, her interpretations would be misleading to the jury as facts as to whether she was required to maintain this or not, which is a legal question for the jury in this case.
Sure. My experience in dealing with these types of questions, that being relevance and the line between expert and lay testimony, is that they are uniquely suited to contextual interpretation. Therefore, I'm not overruling your objection, but I just ask you to raise it when the evidence is elicited. Okay. But
Understood, Your Honor.
Thank you for making me aware that you do object to that testimony.
Thank you. And with that, we can move on to defense's substantive motion.
Sure. Ms. Doig, do you have substantive matters to take up prior to opening?
Your Honor, our substantive motion was what Ms. Nickel talked about earlier. It was the subsequent remedial measure of the light bulb.
Okay, and my understanding, there's an agreement on that we discussed, and there's a stipulation, correct?
That's correct.
Yes,
With
Your
that-
Honor.
With that, it sounds like we're ready to proceed to opening statements. Plaintiff, you may proceed.
Thank you, Your Honor. Just a moment to get my technology set up here.
Sure.
Okay. Whenever the court is ready.
You may proceed.
Members of the jury, on January 23rd, 2019, the hazards hiding in the shadows behind Chime's department store led Mr. Gilmore to slip and fall and permanently injure himself. The hazards that, as we will show you today, the defendant corporation created, knew about, and chose to ignore. Let me paint you a picture about what happened on January 23rd, 2019. This is the area in question, the area where Mr. Gilmore, the plaintiff in today's case, slipped and fell and permanently injured himself. Now, looking at this photo, any reasonable person can see that the area is not in the best state of repair. You see the stairs are falling apart. There's no guardrail on this landing, and the area, generally speaking, doesn't quite look in tip-top shape. So on January 20, 2019, Mr. Gilmore stepped outside to take his smoke break at the area his employer had designated for his smoke break, this spot in particular. And he stepped outside the door and he went down those steps. He took his smoke break, turned around, and went back up those steps. He made it up to the top of the landing, and something happened and his foot slipped. He went crashing to the ground, and as soon as he hit that concrete, he knew something wasn't right. Now, keep in mind, members of the jury, these hazards, although hazards and not great, aren't that problematic in the daytime. But you see, when Mr. Gilmore went out to take his smoke break, the picture looked more like this. It was dark. It was after sunset, and Mr. Gilmore had went outside to take his smoke break. Now, you would think there would be a light outside. There'd be some way for the employer to light the area in which they were required to take their smoke break. The same place they were required to take out the trash, as you can see the dumpster right there. But members of the jury, as the evidence will show today, there may have been a light out there. There was no ability for the employees or Mr. Gilmore to turn it on. And that is what this case is about. The light. The lack of light that caused Mr. Gilmore's injuries on January 23rd, 2019. Now, let's talk about my client, Mr. Gilmore. He was a loyal employee of Chime's department store for 10 years. For over 10 years, he had been a cashier at this store, welcoming customers, checking them out, making small talk. He had done everything he was supposed to do. And when he was told to do something, he did it, and diligently. On January 23rd, 2019, when he was required to go out to that back area for that smoke break, he did it, regardless of whether he thought it was safe or not. And that is what this case is about, members of the jury. It's about the negligence of the defendant corporation. It's about the hazards hiding in the shadows. It's about the choices the defendant corporation did not make. The choices that led to Mr. Gilmore sitting here today, unable to walk the same. So let's talk about what you're here to decide as the jury. Because as the jury today, you're here to determine negligence. You're here to determine whether Chime's department store was to blame for Mr. Gilmore's injuries. So let's break that down. I want you to pay close attention to 3 issues throughout today's trial: notice, risk, and choices. starting with notice. The defendant corporation, as you will hear today, had notice of this incredibly dangerous area. Specifically, they had noticed that the lack of a light outside was a problem, that it was a hazard. You see, you will hear today that Mr. Gilmore himself had reported to the defendant corporation, hey, there's no light out back. Please help us get a light to turn on. He had reported this multiple times, but you will also hear today that there was a prior incident. In which the defendant corporation's findings were, hey, we should install a light out back. They never installed a light out back prior to the defendant's injuries. They were even asked multiple times by people at OSHA, people at other organizations and other groups, hey, it seems like this could be dangerous. Do you have a light outside? And every time, the defendant said, oh yeah, we have a light. We have it on a timer. It comes on. Members of the jury, there was no timer. Or if there was, it certainly did not work. That brings us to the issue of risk. You see, the defendant corporation knew there was a risk. They had knowledge that the light outside, there's no capability for their employees to turn it on at night, that there was a risk that their employees would not be able to see. But that was not the only thing the defendant had knowledge of. Now, I want to be very clear. You're likely to hear about a lot of different factors regarding the conditions out back of that building throughout this trial. I anticipate that Ms. Deutsch will tell you a lot about the guardrail and the concrete out there. But I want to be very clear. The guardrail, the lack of the guardrail, the concrete, those are not the things that we will show you caused Mr. Gilmore's injuries. But they are relevant for one fact. They are relevant because the defendant knew there was no guardrail out back. The defendant knew that the concrete was falling apart. So regardless of whose job it was to repair the concrete or the guardrail or who had ownership out there, or all these questions the defendants will raise for you today, regardless of those questions, it knew those were there and they knew there should have had a light. Yet they did nothing. And that brings us to their choices. Chime's choices. You see, the defendant made several choices. They chose to ignore the hazards and instead hid them on January 29th, 2019. Their choice, specifically their choice not to take the simple step of installing a light switch, forever impacted Mr. Gilmore. Members of the jury, it was as simple as that. Installing a light switch. That's it. As simple as a light switch. Today, we know that it was feasible for the defendant to have installed that light switch. We know that that was something they could have done and chose not to. Now, today as the plaintiff, we have the burden. We have the burden to prove to you that it was more likely than not that the defendant corporation was negligent, that Chimes Corporation was negligent. And we embrace that burden. And we ask you again not to get lost in the weeds. Don't get lost in the weeds of the guardrails or the concrete or ownership of those factors, because what we will show you today is that there is one thing that the defendant corporation absolutely had ownership or control over. And that's that light switch. So when I get up here at the end of the trial and review the evidence with you, I will ask you to return the only verdict that aligns with justice. Because the defendant allowed their hazards to hide in the shadows. So at that time, I will ask you to find Chimes. I will ask you to find Chimes liable. Thank you.
Okay, thank you, Ms. Nickel. Ms. Doig, does the defense wish to make an opening statement at this time?
We do, Your Honor.
Okay, you may proceed when you're ready.
What happened to the plaintiff was a 1 in 10,000 chance. January 23rd, 2019 was the over 10,000th time that the plaintiff walked up and down that 2.5-foot staircase at Chimes department store. Each of the times before were the same. There wasn't a guardrail. Some patches of concrete on the edges had been missing from wear and tear. There was no outdoor light. Members of the jury, there were no hazards hiding in the shadows. Because for the plaintiff, well, she knew the staircase better than almost anyone. Because for each of those 10,000 times that she walked up and down those stairs, she didn't trip, she didn't fall, she never got hurt. Up and down, day after day, year after year, across a decade. January 23rd was different. Not because of anything that the Chimes department store did. It was only different because of what the plaintiff could control. Opposing counsel just mentioned the importance of choices. And you see, as the plaintiff walked up these stairs, she had thousands of times before to go back inside after a smoke break. She had a choice. You see, her friend was standing at the top platform, holding the door partway open. You just saw a picture of an outdoor space, those stairs, when it was dark out. But when the plaintiff was walking these stairs, her friend opened the door to the inside, and the light was showing. As she walked up those stairs, though, her friend was blocking part of the platform because she was holding part of the door open. Instead of waiting for her friend to go inside or asking her friend to move, the plaintiff decided to just go for it. She was cold, she was tired, and she just wanted to get inside. So in her rush, she decided to stretch out around the door into the wind on the edge of the platform, where she fell. A 1 in 10,000 fall over the decade that she had worked at Chimes. And the only thing different in those thousands of times was her own conduct. Now, despite the plaintiff's accident being a 1 in 10,000 chance, she filed this lawsuit against her former employer, the Chimes department store, claiming that Chimes was responsible for her injuries. I'd like you to meet the owner of Chimes department store, Reese Geller. Mr. Geller, thank you. Mr. Geller is the owner of Chimes department store, which has been in the Geller family, well, since Mr. Geller was in diapers. It's a family business started by Grandma and Grandpa Geller, passed down to their children, and then passed on to Reese Geller when he was in his 20s. It's a department store right here in Waco, filled with odds and ends, household items, clothing that serves the people of Waco and employs the people of Waco, including the plaintiff. Now, as far as Chimes department store was concerned, they did everything they were supposed to do. You won't just have to take my word for it, or even Mr. Geller's word for it, because there's a government agency known as the Occupational Safety and Health Administration. You may know them as OSHA, who checks to make sure that businesses and building owners are following the law and are safe. We aren't going to hide from you what that backloading dock looked like. We're not going to dispute that the stairs were old and parts of it were worn. But under the law, a 2.5-foot staircase doesn't have to be perfect to be safe. An OSHA representative came out and inspected the Chimes family business. They walked down those same stairs that the plaintiff walked down 10,000 times before. And after they did, they left. Without falling, without getting hurt, without issuing any kind of citation to Chimes department store. Members of the jury, there's another problem with the plaintiff's claim. Now, I just told you that Chimes runs its business here in Waco. But the actual physical building that they're operating out of, they don't own it. They're just a tenant of a bigger company called Kermit Realty. Now, today you'll see the lease between Chimes and Kermit Realty. You'll learn that Chimes rented the store, and to Mr. Geller, that meant that they were responsible for the safety of the inside. The lease called a demised premise. And Kermit Realty, their landlord, they were in charge of the outside, the common area, the area where the plaintiff was injured. And though you'll hear that these steps were safe, even if there was a problem, it wasn't the responsibility of the renter to fix the problem of the owner. Because those steps weren't built by Chimes, they weren't modified by Chimes, they weren't owned by Chimes. It was Kermit Realty who was responsible for them. 10,000 times, going up and down those stairs. One time falling. 99.99% of the time, no problem. Numbers don't lie. At the end of today's trial, it will become clear. This wasn't unreasonable. It was unlucky. A 1 in 10,000 times gone wrong. And that's why I'll return to you and ask you to weigh the evidence that you saw and ask you to find Chimes department store not responsible.
Okay, thank you, Ms. Doig. Is the plaintiff ready to begin their case in chief?
Yes, Your Honor, the plaintiff is prepared to call our first witness.
You may do so whenever you're ready.
Thank you, Your Honor. At this time, the plaintiff calls Miss Gilmore, to the stand.
Ms. Gilmore, you're advised that you have been previously sworn and have the obligation to tell the truth today, okay?
Yes.
All right, Ms. Nickel, you may begin when ready.
Thank you, Your Honor. Miss Gilmore, can you please introduce yourself and spell your last name for the jury?
Yes, my name is Jordan Gilmore and my last name is Gilmore.
Now, Miss Gilmore, we're aware that you're the plaintiff in today's case. So can you tell us, why did you bring this lawsuit?
I fell and got really hurt, and it wasn't a good thing that happened.
Well, Miss Gilmore, we'll get more into what happened here in a moment, but I want to let the jury get to know you just a little bit more. Where are you from?
I'm from here in Waco.
And what is your job?
I don't have a job right now, but I used to work at Chimes department store as cashier.
And how long did you work for Chimes?
About 10 years.
So let's turn to the day or night in question in this case. I'm going to have, Your Honor, permission for my co-counsel to publish what was previously admitted during pretrial orders as Exhibit 19.
You may.
Thank you. Now, looking at this photo, Ms. Gilmore, tell us what happened on January 23rd, 2019.
So I had gone outside during my shift to take a smoke break, and I had gone down and smoked where I usually do. And then when I was walking back up the stairs is when I fell.
I want to break that down a little bit. As you were walking up the stairs, what exactly happened when you went up the stairs?
My coworker who had gone out to smoke with me was holding open the door in such a way that it made it difficult for me to walk up the stairs. And since there was nothing to hold on to, I usually had to brace myself using my hands on the wall. And I wasn't able to do that. And there was nothing else for me to hold on to.
And Ms. Gilmore, I want to be clear because we've admitted this into evidence. So we know it's a fair and accurate depiction of this area on the day in question. But you mentioned this happened at night.
Yes.
Correct?
Yes, it was dark.
Then, Your Honor, permission for my co-counsel to dim the photo.
Is there any objection to altering the photo by dimming it?
No, Your Honor.
Okay, then you may proceed.
Thank you, Your Honor. Now, Ms. Gilmore, is this closer to what it looked like that night?
Yes, that looks more like it.
And I'm going to go ahead and have Mr. Meinkoth take this down. I want to be clear. Did you ever file an incident report with the defendant?
Yes, I went and told my manager right after it happened.
Can you go ahead and turn to Exhibit 10 in your packet?
Yes.
Do you recognize that document?
Yes.
What is that a document of?
Sorry, 1 second.
That's okay. If you need a moment to review it, you can.
Is it a photo? Sorry.
You're okay. Exhibit 10. It should be the incident report that I just mentioned.
Okay,
It's all good if you need a moment. No problem.
got it.
Perfect. Is that the incident report we just spoke about?
Yes.
And does it fairly and accurately reflect the incident report as you're aware of it?
Yes.
Now, at this time, we'd move Exhibit 10 into evidence.
It's my understanding that, oh, that was 11. My mistake. Is there any objection to Exhibit 10 being admitted?
No, Your Honor.
Exhibit 10 will be admitted.
Now, Miss Gilmore, I want to talk just briefly. We aren't here to discuss damages, so I don't want you to go into any detail. But did you suffer injuries as a result of your fall?
Yes. Yes. My knee was pretty much destroyed and I had to get a knee replacement.
Now, Miss Gilmore, let's take a step back and talk about the conditions that were present on the night of your accident. Now, we saw that dimmed photo. It was very dark. Were you able to see that night?
Not really, no.
What time were you outside, roughly?
About 7 p.m.
So was that after the sun had set?
Yeah, it was winter, so it was cold and dark.
And did you have any ability to turn on a light?
No, we're not able to do that. It's not located inside our store.
And had you ever told anybody at Chimes about this?
Yes, I went ahead and told my manager.
And what had your manager previously said?
That she'd spoken with the owners and it just wasn't really their priority to fix right now.
And had they told you whether they were capable of fixing it?
Not sure. Just probably
Mrs.
not. Yeah, sorry.
That's okay, Ms. Gilmore. To be clear, at the time of your accident, there was no light outside.
No.
So I want to go ahead and talk for a second why you were even out there in the first place then, Ms. Gilmore.
That is out there because that's the place that they told us to smoke.
And had you been a smoker for a while?
Since I was 16 or 17, long time.
So did you regularly smoke?
Yes, it was about a pack a day.
So to your knowledge, were your managers and individuals at Chimes aware that you smoked?
Yeah.
So you mentioned that you were required to go out there to smoke. How did you learn that you were required to do that?
They sent out a store memo telling us that's where we needed to go.
I'm going to go ahead and have you turn to Exhibit 1 in your packet and let me know when you're there.
Got it.
Perfect. And do you recognize this document?
Yes.
What is it?
It's the memo that our manager sent.
And does it fairly and accurately reflect the memo?
Yes.
Your Honor, at this time we move Exhibit 1 into evidence.
Without objection.
Exhibit 1 will be admitted.
And permission for my co-counsel, Mr. Manco, to publish.
You may.
Thank you. There we go. Now, I'm going to go ahead and have Mr. Manco zoom in here on this second sentence in the first paragraph. Can you read for us, Miss Gilmore, what this says starting at "as you have"?
Yes. So as you have been told before, if you're going to smoke, you need to smoke out behind the store where our dumpster is. That is the only place that you should take smoke breaks on the premises.
Thank you, Mr. Mancos. We can pull that down. And just to be clear, Ms. Gilmore, if you weren't a smoker, could you have avoided going out into that back area?
No, that was where we had to take the trash out, which I did probably 2 or 3 times a shift.
No further questions, Your Honor.
Okay. Ms. Doig, do you have a cross-examination for this witness?
Yes, Your Honor.
And you may proceed whenever you are ready.
Miss Gilmore, January 23rd, 2019, it wasn't the first time that you used those back stairs, right?
No.
Wasn't the second time.
No.
Let's look at how many times you used those back stairs. Your Honor, permission to create a demonstrative?
Yes, proceed.
Now, Ms. Gilmore, you just told us that your accident occurred on January 23rd, 2019. Is that right?
Yes.
And you worked for Chimes for 10 years before your accident.
Yes.
During those 10 years, you went out to the loading dock to smoke cigarettes.
Yes.
You'd also go out there daily to take out the trash.
Yes.
In fact, you'd estimate that you were out there at least 20 times a week.
Yes.
So if my math is correct, that's about 1,000 times a year, right?
Sounds good.
And over 10 years, that's about 10,000 times, right?
Yes.
And in those 10,000 times, you went up and down the stairs. You never slipped before, did you?
I didn't know.
You never tripped.
No.
Never fell.
No.
This accident, it was the first time you ever had an issue using those stairs.
Yes.
Your Honor, permission to mark this demonstrative as Exhibit 41 to preserve?
You can mark it and preserve it as, we'll call it Defense 1A to designate that it's demonstrative and it won't be sent back with the jury. Okay?
Sounds good to me. Thank you, Your Honor.
All right, go ahead.
Your Honor, permission to republish Exhibit 19?
Yes, you may proceed.
Now, Ms. Gilmore, this is what you just talked about with your attorney, right? These are the steps that you were walking down.
Yes.
And after you walked up and down those stairs 10,000 times, you became pretty familiar with them, right?
Yes.
You knew how many steps there were.
Yes.
You knew there wasn't a guardrail.
Yes.
You knew that you could hold onto the wall if you needed support.
Yes.
You also knew that the top platform where those doors were wasn't super big, right?
Yes.
You knew that if you didn't open the door all the way, you could actually make it harder for yourself to get onto the loading dock.
Yes.
That first door, that front door, it opens outwards, right?
Yes.
So if that door is open, it's harder to get onto that dock and get inside.
Yes.
Let's talk about what you did that night. You told us that you walked out around 7 p.m., right?
Yes.
And it was dark out.
Yes.
Now, you had an iPhone with a flashlight on it at work, right?
Yes.
But even though you knew it was dark, you didn't take it out with you, did you?
No.
But there's something else you could have done, wasn't there?
Could have been a lot of things.
Miss Gilmore, you knew what was behind those two doors, didn't you?
Yes.
There's light.
Yes.
If you open those two doors, well, it wouldn't really look like this, would it?
Not a lot of light.
Well, if you open those two doors and all the lights were on inside, all the light would spill out into the outside, right?
Some.
And the night that you were walking up those stairs, the door was open, wasn't it?
Yes.
Now, I want to talk to you first about your trip down. As you walked down those stairs, you were holding onto the wall, right?
Yes.
You stopped at the bottom
Yes.
to smoke a cigarette.
Yes.
On your journey down those stairs, there weren't any issues, were there?
No.
And after you smoked that cigarette, you were pretty cold, weren't you?
Yes.
You wanted to get inside as quickly as you could.
Yes.
It was cold that night.
Yes.
It was windy.
Yes.
You wanted to be inside.
Yes.
So you started hurrying up the stairs, right?
Yes.
As you hurried up the stairs, you saw your friend holding the door open, right?
Yes.
And how your friend was standing, he was kind of blocking the light, right?
Yes.
It made it a little darker than it usually was.
Yes.
And how your friend was standing, it was also blocking your path onto the platform.
Yes.
Your Honor, permission to publish Exhibit 5. It's one of the stipulated exhibits.
Yes, you may proceed.
So right there where that box is, that's where the door was, wasn't it?
Yes.
And that little space after it, that was the only space that you could fit on, right?
Yes.
Now, you could have asked your friend to close that door, right?
Sure.
Could have asked your friend just to move out of the way so you'd have more space.
Yes.
But since you were in a hurry up those stairs, you decided to just try to go around your friend in the door.
Yes.
You kind of Spider-Maned around it and put your foot on the other side of it, right?
Yes.
And you took your hand that was on the wall off of it.
Yes.
And it was in that hurry, when you took your hand off the wall, when you Spider-Maned around the door, did you start to fall?
Yes.
And then you jumped.
Yes.
Past the witness.
Okay, Ms. Nickel, do you have a redirect for this witness?
Yes, Your Honor.
You may proceed.
Miss Gilmer, you just spoke on direct about how there was light inside the building, but not outside. So was there a reason you left the door open and didn't shut it?
It just helps let a little bit more light outside. But like I said, it's not a lot.
And what was the weather like?
Cold and windy.
So was there a reason you had your friend holding the door in that position?
I don't quite remember.
That's okay, Miss Gilmer. So given that it was cold and windy, as you just testified,
Yes.
was there a reason your friend had to hold the door there?
So that it wouldn't get stuck shut. Yes, so that the door wouldn't get stuck shut.
And who required you to be out back in that location in the first place?
Times. The store itself did.
No further questions, Your Honor. And this witness
Okay.
may be.
Sure, I assume there's no recross, Ms. Doig?
Not necessary, Your Honor.
All right, then the witness may step down. And Ms. Nickel, if you don't envision a rebuttal case, then I'll allow you to excuse her, but that's up to you.
Yes, Your Honor, I do not envision a rebuttal case, so she may be excused.
Okay, the witness will be excused. Ms. Nickel, you may call your next witness.
Yes, Your Honor, at this time, we call Miss Kelly Danes by way of deposition.
Okay, you may proceed.
Thank you. I'll have my co-chair come up on the screen and do the question answer format with me.
Sounds good.
Great. Referring the court and opposing counsel to page 2, line 6 of the deposition. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Kelly Danes.
Line 12, tell us about your education.
I have a bachelor's of science in mechanical engineering from the University of Wisconsin-Madison.
And since graduating from college with your mechanical engineering degree, have you gotten any further education?
Sure, I've attended various seminars offered by the National Academy of Forensic Engineers.
Moving to page 3, line 2, what have you done to become a professional engineer?
Well, you have to graduate from an accredited engineering program, which I did. Then you have to pass the fundamentals of engineering exam, which I did. Then you work as an engineer for 4 years before you take the professional engineering exam. So I took that as well and I passed.
Moving to page 4, line 14. Over the course of your career, how many incidents have you investigated?
Over 60.
And how many times have you been deposed?
About 20.
And how many times have you testified at trial?
Twice prior to this.
Moving to page 5, line 14. All right, Kelly, I want to move on and talk about your work in this case. What did you review in coming to your opinions in this case?
I reviewed the deposition of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, a number of provisions from the International Building Code, and I conducted an inspection of the location of the fall and took pictures of that area.
Page 8, line 16. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulation from the Occupational Safety and Health Administration apply to the stairs and landing in question, and the facilities in question must be in compliance with those codes and regulations.
Page 9, line 9. All right, so which portions of the IBC codes and the OSHA regulations did you find important in this case?
First, the general duty clause in the OSHA regulations, which can be found in 29 USCS 654, and the maintenance provisions under section 3401.2 of the IBC.
Why are those significant in this case?
These are general provisions that require an employer and/or the party that is responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition, free from recognized hazards. Here, as you can see from the photographs that I took during my inspection of the stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of a light switch to turn on the light above those stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant didn't have such a program and never identified or corrected these hazards.
Page 11, line 6. What other portions of the IBC codes and the OSHA regulations did you find important in this case?
OSHA 1910.37B1 and IBC 1006.1, which both deal with lighting.
And why are those significant?
Well, 1910.37B requires that lighting must be adequate and appropriate for a building exit like this one. And 1006.1 requires that any means of egress must be illuminated at all times the building is being occupied. In this case, there was a light above those stairs, but there was no switch for that light inside the Chimes store. So there was no way for employees to turn that light on when they went outside at night. A switch like that should have been installed long before this incident to make sure that employees could see where they were stepping.
No further questions from this witness, Your Honor.
Okay. Ms. Doig, do you have any excerpts from this deposition that you'd like to read and cross?
Yes, Your Honor. We provided these to opposing counsel pre-trial. May I use my second chair as well?
You may.
Referring the court and counsel to page 10, line 19. Do the OSHA regulations place any requirements on employees?
Yes, there is a general duty requirement in 29 USCS 654B, which says that employees also have to comply with the OSHA standards and regulations and basically have to be responsible for their own actions.
Page 11, line 20. Have you ever seen that light above the stairs turned on at night? Do you know how much light it would have provided?
No, I've never seen that. I just know that it wasn't on and there was no switch for it.
Page 14, line 12. You would agree, though, that this area was used by Chimes as a loading dock at times.
Yes, at times.
And a guardrail around a loading dock would certainly inhibit Chimes' ability to use it as a loading dock.
Yes, it would make it difficult.
Can you point to any specific regulations or codes related to how or if employers or others must place guardrails around a loading dock?
No, I'm not aware of anything like that.
Nothing further.
Okay. Ms. Nickel, do you have any redirect portions to offer?
No, Your Honor.
All right, then you may call your next witness.
Your Honor, with that, the plaintiff rests and we are ready to proceed to any halftime motions at this time.
Okay. Defense, do you have any matters to take up outside the presence of the jury?
Yes, Your Honor.
Okay, let's go ahead and do that.
Yes, Your Honor. Your Honor, we have a Rule 50 motion taking all the evidence in the light most favorable to the non-moving party, which would be the plaintiff in today's case. They still haven't proven that this was an unreasonable risk of danger, the very first element that they need to prove in a negligence claim. What we heard today is that the plaintiff had walked up and down those stairs 10,000 times, and only once had she been injured. We haven't heard about any other injuries that occurred on this property. All we've heard about was 10,000 flights on this step, and only once was there an injury. Your Honor, that's 99.99%. No injuries, no problems. It's not unreasonable. And for that reason, we ask that you dismiss this.
Okay. Ms. Nickel?
Yes, Your Honor. In viewing the evidence in the light most favorable to the non-moving party, a reasonable juror could find that we have established all three elements of negligence, including the requirement of showing unreasonable risk. Just because my client, Miss Gilmore, seems to be good at Taekwondo and parkour and avoided injury prior to this time, does not mean that the risk was not unreasonable. It just means that Mr. Gilmore was able to, or Miss Gilmore was able to avoid injury in the first place. Therefore, we have shown that there was an unreasonable risk in that area, that the defendant knew there was no guardrail, knew that the concrete was deteriorating, and yet did not install a light switch that they were capable of installing. Therefore, we would ask this motion be denied.
Ms. Doig, you get final word.
Your Honor, again, numbers don't lie. We have 99.99%, a 0.01% chance of injury. That's not enough to show unreasonable risk under the burden. That's why we ask you to dismiss this charge.
Okay. I appreciate the argument from both of you. I'm going to deny the motion without prejudice at this time. So we are ready to move on to the defense case in chief, which I assume the defense wants to put on a case in chief.
We do, Your Honor.
All right, that's what I thought. We're moving at a pretty good clip here, so unless y'all feel otherwise, I'd say we can afford to take a 10-minute break and come back at 4 o'clock Central Time to begin the defense case in chief. Does that sound good to everyone?
No objection from the defense.
And
Thank you, Judge. Yes, that's awesome. Thanks.
the one thing I'd ask is if the second chairs are keeping time. I have been keeping time, but I'd like to probably check with them and see what they have so that it doesn't become an issue later on down the road. Okay. All right. See y'all back at 4 o'clock Central. Okay. Is counsel ready to proceed with the defense case in chief?
Yes, Your Honor. The defense calls Reese Geller.
All right. Mr. Geller, you're advised that you have been previously sworn and have the obligation to tell the truth, okay?
Okay. Yes, Your Honor.
You may proceed when you're ready, Ms. Doig.
Yes, Your Honor. Good afternoon. Please introduce yourself to the jury.
My name is Reese Geller.
Where do you live, Mr. Geller?
I live here in Waco, Texas.
Have you always lived here in Waco?
I have.
Did you go to college?
I went to Baylor University here in Waco.
Are you currently the owner of Chimes Department Store?
I am.
Objection leading.
Overruled.
Are you currently the owner of Chimes Department Store?
Yes.
Tell the jury how exactly you became the owner.
Well, my grandpa started the department store originally, and so it's a family business. However, I didn't start working until I graduated from Baylor, and I started at the towards just an entry level job and worked my way up. So, and then I was put in charge of the business about 10 years ago.
Can you tell us, so what kind of things does Chimes Department Store sell?
It's kind of similar to a J.C. Penney's or a Macy's. So there's kind of clothes and shoes and tools and within that realm, kind of a little bit of everything.
Is Chimes in Waco?
It's just in Waco. Yeah, it's a single location.
Who owns the building where Chimes is located?
The owner of the building is the Kermit Realty Group.
What's your relationship with Kermit Realty Group?
They are our landlord that we have a lease with, and we're a tenant.
What's your understanding of Chimes Department Store's responsibilities for the store?
We're responsible basically for everything in the store, and Kermit is responsible for everything outside the store.
What makes you say that?
It's in the lease.
Objection. Your Honor, I would re-raise our earlier objection. I have no problem with this witness stating that he understood he had to do what was in the building or outside the building, but talking about what was in the lease and the interpretations there where the 401 and 403 issues lie.
Response, Ms. Doig?
Your Honor, not only is the lease already pre-admitted, so he's just reading admissible evidence, it's already in evidence, Exhibit 11, but like I mentioned earlier, this witness the plaintiff has to prove today that what Chimes Department Store did was outside the ordinary care of a company, something that other companies in the normal course of business would not have done in similar or same circumstances. How this witness interprets the lease, what they think their responsibilities are based on the lease, goes directly to that. Additionally, Your Honor, we filed an affirmative defense in today's case, pleading that it was actually Kermit Realty Group who is responsible for maintaining that outside area. And this lease goes exactly to this. This witness isn't going to be explaining what legal terms are except for what it says on the lease, and basically just talk about how, based on what he read on the lease, what actions he took or didn't take, what responsibilities that he believed he had and responsibilities he didn't think he had. We're not offering this as expert testimony, just how this informed this expert's course of action, which goes directly to the negligence charge and our affirmative defense.
Ms. Nickel?
Yes, Your Honor. None of this evidence goes to what other companies would do. So this doesn't go to Ms. Doig's argument about the ordinary or reasonable care in this case. It's only what this witness interprets what he should have been doing. And that's exactly our issue with this. Just because they pled that Kermit was contributory negligent doesn't mean this witness, as a lay witness, can testify as to the meaning of a lease agreement and its terms. the fact that he thinks he was or was not responsible does not make a fact of consequence in today's case as to whether Kermit or Chimes was legally liable, more or less likely, and would mislead the jury as to whether he was, in fact, legally required or not required to do certain things.
Certainly. I think that point is well taken, that he's not an attorney and he can't make legal conclusions. That's for the jury to decide. I also think you've eloquently stated that point, and they've heard everything that we've said on this point. And so let's skin this cat this way. I will instruct the jury that they are only to receive this testimony as the witness's explanation for his actions or inactions, not as a legal conclusion, but I will overrule the objection and allow the testimony to proceed. Okay?
Understood, Your Honor. Thank you.
You may proceed, Ms. Doig.
Your Honor, may I pull up Exhibit 11?
You may.
Now, Mr. Geller, you just told us that you believe that your family store was responsible for the inside and that Kermit Realty Group, the landlord, was responsible for the outside. What does the lease call the inside of the store?
The lease specifies that it's called the demised premises.
And how does the lease define demised premise?
Specifically, it says approximately 18,000 square feet of space in the shopping center, and being the space hatched on the site plan, which shall have a minimum of 100 feet of clear interior width between demising walls along the front of the demised premises.
Besides this explanation of the demised premise in the lease, were there any other diagrams that showed what area you were renting?
Yes.
Are you referring to the diagram on the last page of Exhibit 11?
That's correct.
Showing the jury this diagram, can you explain what it shows?
Objection, Your Honor. I don't believe this has been admitted into evidence unless I am incorrect. So I would just ask that that be done before we show the jury.
Your Honor, this is in evidence. This is Exhibit 11.
Oh, I apologize. There's a separate exhibit that, okay, so you're just doing the one on the back of the page 11.
Correct.
Thank you. I apologize for the confusion.
Okay. No problem at all. You may proceed, Ms. Doig.
Now, referring to this diagram that we're looking at the screen, can you explain what it shows?
Yes. The part where at the top where it says Chimes, that block is where the store is. Out in front of it, but down towards the middle and then the bottom is the parking lot. And that center strip of the parking lot, there's a dotted line around it. That's cross-hatched along with the Chimes piece. And that's what we're responsible for, or what Chimes is responsible for.
So I'm marking that crosshatch section you just referred to in green. And you mentioned that there was another part in the back. What exactly was that?
The back part is, according to what I've read in the lease and what they put, it's called a common area, and is a part that we're not. It's not a crosshatched area. It's not a part that we're responsible for.
And in terms of your store, what actually was in that red area that we just marked in the back?
That is a loading area for us. We use that as a place for almost like a loading dock of where product comes in and we're able to load it into our store.
Your Honor, just for the record, we marked in green the Chimes area that the witness said that he was responsible for, and in red, the loading dock. Now, that loading dock, what did you use that for?
We used it, as I said, to bring in products. So there was no real convenient place in the front to be able to do that. So it made the most sense to use the back, and to any merchandise, anything that we were selling, it was easily accessible from the back in that common area right there that's marked in red.
Now, you've referred to this as a common area, and I want to turn your attention back to page 9 on the lease, specifically section 6.1.
Ms. Doig, may I interject real quick?
Of course, Your Honor.
Did you actually intend to mark exhibit 11 with the darkened area? that we saw before?
Yes, Your Honor, just for demonstrative purposes.
Okay, can we go ahead and mark that for the record as defense 2A so that we leave the original exhibit 11 unmarked?
Yes, Your Honor.
Okay, sorry, you may proceed.
Now, directing your attention to page 9 of the lease, specifically section 6.1, how did the lease define common areas?
Yeah, it says the term common area is defined for all purposes of this lease as that part of the shopping center intended for the common use of all tenants, including among other facilities, private streets and alleys, loading areas, service areas, common utility lines.
What did the lease say about who is responsible to maintain the common areas?
The landlord, Kermit Realty Group is, and it says that they shall be responsible for the good and safe operation, management, and maintenance of the common area.
So I want to talk to you about the actual loading dock itself. We've heard testimony today that there is no guardrail. Do you know why not?
Yes.
And why not?
We, as per the lease terms, according to Kermit, if we wanted any adjustments to the common area, we had to put in a request from them as they control it. So we put in a request to remove those rails in order to facilitate its use as a loading area. And per the terms of the lease as well, offered or had to put up the cost for any removal of those. And so they responded and did that, and then we covered the cost.
So you said you submitted a request. I have that request marked as Exhibit 13 on page 163 of the record. Can you turn there and let me know when you're there?
Yes, I have it in front of me.
Do you recognize this?
I do.
What is this?
This is the email that I sent to Reginald Kermit, of Kermit Realty Group, to request per the terms of the lease, the removal of the railing from the steps and the landing outside of the exit doors.
Your Honor, I offer Exhibit 13.
Any objection to Exhibit 13?
No objection to Exhibit 13, Your Honor.
Exhibit 13 is admitted.
Permission to publish?
Yes, you may.
Mr. Geller, is this email that we were just talking about?
Yes.
And you said that you sent it to the landlord. When did you send this?
I sent that on January 15th, 2005.
And you told us that you asked to move down the railing from the steps. Why did you ask them to do it rather than just doing it yourself?
Well, as I said, that's not an area that we have control over, according to the lease, and so it would be breaking that agreement if I did that myself. So I requested from Kermit, as we were supposed to do, that they would do it.
And when you sent this email, did they say, no, you're the one responsible for taking down the fence?
No, they did not say that.
Did they take down the fence?
They did.
So let's focus on what the loading dock itself actually looked like. I'm going to republish that exhibit, Exhibit 2. In one moment, there may be a technical problem. Or we can pull up 19. It's okay, Mr. Friedman, if there's a problem. So I want to talk to you just about the condition of the concrete. What was the condition of the concrete after they removed the loading dock? Or, excuse me, the guardrail.
It was smooth for the most part. There was a couple places where it was a little chipped or cracked or so after they got done removing the railing.
Did this concern you?
No, it didn't.
Other than the plaintiff in today's case, focusing on the plaintiff in today's case, how long did she work for you?
She worked for 10 years.
And before this accident in those 10 years, are you aware if she walked up and down those stairs before?
Yes.
Do you have other employees who would walk up and down those stairs?
Yes.
Were you aware of any other time during those 10 years that the plaintiff worked for you? She slipped on the loading dock.
No. No, not that I'm aware of.
Before this accident, were you aware of any other time that the plaintiff was injured in your store?
No. Not that I'm aware of.
Nothing further. Pass the witness.
Okay, Ms. Nickel, do you have a cross-examination for this witness?
I do, Your Honor, and I have a bit of a unique request given the nature of this forum before I proceed. And that is that upon request in my cross-examination, if we could have opposing counsel republish what was admitted as Defense Exhibit 2A. Fortunately, we were not able to review that demonstrative before trial today, so I wasn't able to create one myself. So I would ask that we republish that at the appropriate time, if that's okay with Your Honor.
Ms. Doig, will that be possible?
Of course. You just mean Exhibit 11 with the highlights?
Yes.
Of course.
Thank you so much.
Perfect.
Do you want it right now? I'm sorry, Your Honor. Would you like it right now? Is there a certain time you want me to pull it up?
I can request it it won't be right now. At the certain moment, I can ask Mr. Friedman if that's okay with the court and with Ms. Doig.
Perfect.
Great. Thank
All
you.
right. Ms. Nickel, you may proceed.
Now, Mr. Geller, I want to just start by talking about some of the things you stated on direct, specifically that this is a family-owned business.
Yes.
And you've been at this business for your entire career.
Yes, since I graduated college.
And you're now the owner.
Yes.
So it's fair to say you have a stake in the business's success.
Yes.
Then let's talk about why your employees were out in the back of your building the night they were injured. You're aware that your employees smoke.
Yes.
You're not so fond of that fact, though, are you?
I don't necessarily have a personal opinion on them smoking, if that's what you mean.
Well, I want to be very clear, Mr. Geller, because previously you stated that you didn't want them smoking out front because that would look trashy.
Oh, yes. Sorry. In terms of the business, I didn't think it looked very professional to have employees smoking out front while customers were walking in.
So you required them to smoke out in that back area.
Yeah, that was the only other space to do it in.
So for all of those 10,000 times that the defendant was out there, that was because you required her to be out there, right?
If they were going to smoke, I required that they go to the back of the store. Yes.
Well, not only smoke, but that was also where they had to take out the trash, right?
That's correct.
Then let's talk about the condition of that area where you required your employees to be. Now, you spoke on direct about how there was no guardrail.
Yes.
And that's because you asked for it to be removed.
Yes, I requested it.
And you're also aware that your employees sometimes work after dark.
Yes.
So you were aware that your employees would be out there when there was no guardrail.
Yes.
And you knew your employees would be out there in the dark.
Yes. I assumed that the light from the door would be there, but yes.
Oh, you assumed the light from the door would be there. Well, let's talk about the light a little bit more, because I think that's something we can agree you did have control over. Mr. Friedman, can we—
Objection, attorney testimony, Your Honor.
I may proceed with my question, Your Honor.
Yep.
I'm going to have Mr. Friedman republish what was previously admitted as Defense 2A. Now, you spoke on direct, Mr. Geller, about that area in red, right? That was an area you did not have control, right?
That's correct.
And that was where the guardrail and the concrete was, right?
Yes.
But I want to be clear, you did have control of everywhere in the green, right?
Yes.
And you were capable, it was feasible for you to have installed a light switch in that area, right?
Correct.
So in that area in the green, you had control over and the ability to install a light switch that would turn on the light outside.
Yes, I did.
Thank you, Mr. Friedman. We can pull that down now. I want to go ahead now and turn to a new topic. You've been here the whole trial, right, as a representative of the defendant?
Yes.
So you heard Ms. Doig mention that this fall was 1 in 10,000.
Yes.
She said it was just unlucky.
I heard her say that. Yes.
But I want to be very clear, Mr. Geller, this isn't the first time an employee has fallen out back due to a lack of light, is it?
No.
You see, back in 2010, another employee fell out back.
Yeah, that's correct.
And in that report, when that employee fell in that same location, the finding had to do with the light, right? The finding of your company?
Yes, I'm not sure. I don't recall.
Well, let's take a look at that exhibit then. Can you turn to exhibit 14 in your packet?
Give me one. Yes, okay, I have it.
And you recognize this exhibit, don't you?
I do.
This is that prior incident report.
Yes.
And it fairly and accurately reflects that incident report.
Yes.
All right, this time we move exhibit 14 into evidence.
Any objection to exhibit 14?
No, Your Honor.
Exhibit 14 is admitted.
May my co-counsel publish?
Yes.
Thank you. So this is the document we're looking at, Mr. Geller, and I'm going to go ahead and have my co-counsel zoom in on that last page. On the last page of this, it states, when asked, are there any steps that should be taken by Chimes to prevent such injuries in the future? And the answer by your employee was, make sure there is adequate lighting on the loading dock. I read that correctly, right?
Yes.
And you'd agree with me that this incident happened in 2010.
Yes.
9 years prior to Mr. Geller falling in that same location in the dark.
Right.
No further questions, Your Honor.
Okay. Any redirect for this witness, Ms. Doig?
Yes, Your Honor.
You may
Permission
proceed.
to republish exhibit 14.
Certainly.
Now, Mr. Geller, opposing counsel just talked to you about this report that was in 2009. How many years between 2009 and 2019 when the plaintiff was injured?
That's 10 years.
And I want to talk about this incident report. And what was the description of the injuries given by the person who tripped?
They stated, according to the report, they said, I wasn't badly hurt.
And besides this incident that occurred now in 2009, 10 years before the accident, or 10 years before the accident, I'm sorry, and the accident that occurred in 2019, are you aware of any other injuries over those 19 years?
No.
Nothing further.
Okay. Ms. Nickel, any recross?
No, Your Honor.
All right. In that case, may the witness be excused?
Yes, Your Honor.
All right. The witness is excused. Ms. Doig, you may call your next witness.
Yes, Your Honor. We'll call our next witness by deposition. Permission to have my second chair come on screen and read the answers?
Yes, they may.
Bring court and counsel to page 2, line 1. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Perry Hayden.
What do you do for a living?
I am a compliance safety and health officer with the Occupational Safety and Health Administration.
What does the Occupational Safety and Health Administration, or OSHA, do?
OSHA is the government agency that is responsible for making sure that workplaces are safe for the employees that work there. So we provide information, training, and assistance to employees and employers to try to make workplaces as safe as possible and to make sure those workplaces are in compliance with OSHA regulations and standards. We are all about employee safety.
Turning to page 5, line 6. All right, Mr. Hayden, how are you involved in this case?
Well, I conducted an inspection at the Chimes department store in Waco back in 2018. So I assume that's why I'm here.
Mr. Hayden, I'm showing you what's been marked as Exhibit 36. Do you recognize this?
Yes, this is my report from the 2018 inspection of the Chimes department store.
It's Exhibit 36, a true and accurate copy of the report regarding your 2018 inspection of the department store.
Yes, it is.
Why did you inspect the Chimes department store in Waco back in 2018?
It was just a regularly scheduled inspection. We do that all the time. Just show up and do an inspection.
So, were there any complaints that led to this inspection?
Not that I'm aware of. I went out there because it had been a while since we'd been there. That's it.
And turning to page 6, line 8. Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
Did you inspect the area behind the store where there's a little landing and some steps?
Yes, I did.
Turning to page 8, line 20. Is there any OSHA regulation that does specifically discuss loading docks?
Yes, 1910.28B13 clearly states that guardrails aren't required on loading docks because they aren't feasible. You can't very well load something onto the dock with a bar in your way.
Thank you. Nothing further.
Okay, Ms. Nickel, do you have any portions of this witness's deposition to read in and cross?
Yes, Your Honor, we do. I'll give my co-chair a moment to come on screen with me. There we go. Perfect. We'll be starting on page 5, line 6. All right, Mr. Hayden, how are you involved in this case?
Well, I conducted an inspection at the Chimes department store in Waco back in 2018, so I assume that's why I'm here.
Line 23. During that inspection, what were you looking for?
At the most basic level, I'm looking for any kind of condition at the workplace that might be dangerous to the employees working for Chimes.
And page 6, line 11. Did you inspect the area behind the store where there's a little landing area and some steps?
Yes, I did.
Why did you inspect that area?
At the beginning of every inspection, I ask the representative for the employer to outline for me all the areas where their employees work. When I asked that question to the manager at Chimes that day, they told me the employees regularly worked in that area behind the store and took smoke breaks there. So once I had that information, I made sure to include it on my list of areas to inspect.
And when you went out there, what did you notice about the steps in that landing area?
Well, at first, I was a bit alarmed because there were some pretty obvious issues.
Like what?
Well, there were stairs and a landing area, but there were no guardrails anywhere. Plus, the concrete on the edges of those steps and that landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems.
Moving to page 10, line 5. Do you disagree with the assessment of your boss in this email?
No, I don't. I'm a fairly conservative when it comes to issuing citations. Look, I obviously believe that workplaces need to be safe for employees, but that doesn't mean the government should be draconian in enforcing those regulations, especially in times like these when it's hard enough to find a job or a place to do work. So maybe I'm a little bit more lenient than other inspectors. That's certainly possible. But I do my job and I do it well. And we talked about this issue and it was all good. It's not like I've been fired or anything.
Page 11, line 16. Did you ever inspect the area behind the store at night?
No, only during the daytime.
Did you notice a light out there when you were doing your inspection?
Yes, I did. You'll see it noted on my report.
Did you ask the manager about that light?
Yes, I did, like you can see in my report.
And what did the manager say?
The manager told me that they always turn the light on when somebody goes out back at night. So that seemed good enough for me.
No further questions, Your Honor.
Okay, is there any redirect for this witness, Ms. Doig?
No, Your Honor. At this time, the defense rests. Could we get a time check from Your Honor whenever Your Honor has a moment?
Sure, I can give that to you right now. While I'm totaling those times up, Ms. Nickel, do you envision having any rebuttal case?
No, Your Honor, we're ready to proceed to closings.
Okay, so both sides do finally rest and close.
Yes, Your Honor.
And Ms. Doig, for the record, yes?
Correct, Your Honor.
Okay, good. All right. Let's see. Okay, I am happy to hear different opinions from the timekeepers, but what I have in terms of time is that the plaintiff has 12 minutes remaining and the defense has 29 minutes remaining. Is that way off from what the second chairs think?
We had 25, about 25 on our end, but we're happy to split the difference if that makes sense, or we can just take 25.
If you really need the extra 4 minutes, then.
Your Honor, I can assure you I don't.
Okay, good. And for Ms. Nickel, do you object to my finding that you have 12 minutes left, or do you have a different opinion?
I do not currently. I'll check with my assistant really quick. He's typing.
Okay.
I'll make sure he's got the right time, but personally.
Well, if you do, feel free to bring that up when we come back from the break. I want to take a 5-minute break so you can collect your thoughts prior to closing. And let's be back here at 4:35 Central Time. Okay.
Great. And that's what my co-chair had as well. So we'll go with 12 minutes.
Sounds good. See you in 5 minutes.
Mr. Minecoth, if we can do just a quick tech check here.
Absolutely.
All good?
Looks good.
Thank you.
Okay, are the parties ready to proceed with closing arguments?
Yes, Your Honor. And for the record, we would want to re-raise our mid-trial motion at this time. Our motion for a judgment as a matter of law.
Understood. Consider the error preserved, if any.
Yes, Your Honor.
All right, that'll be denied again, and we are ready to proceed with the plaintiff's closing argument.
Thank you, Your Honor. And we would request that we reserve any remaining time for rebuttal.
Why don't we do this? I will allow you to reserve any remaining time up to 2 minutes for rebuttal, okay?
Perfect. That sounds great.
You may proceed.
Thank you. Members of the jury, this case is about the hazards hiding in the shadows. This is about the hazards that the defendant corporation Chimes knew about and yet took no steps to fix. The hazards that have resulted in Miss Gilmore being unable to walk the same. This case is about the defendant corporation being on notice of risk, creating a risk, and then choosing not to fix it. Now, members of the jury, I want to be very clear because Ms. Doig has talked about this case being about the unlucky nature of this event. It wasn't unreasonable, it was just unlucky. The defendant had a choice. He could have stepped differently around that door. Members of the jury, lightning doesn't strike twice in the same spot. And that is what happened here. This was not unlucky. This was unreasonable. So let's talk about why the defendant's actions in today's case were so unreasonable. First, I asked you today to pay attention to a couple of key phrases. Specifically, I asked you to pay attention to risk, notice, and choices. Now, this is a part of your jury instructions that you're about to see when you go back into deliberations. And you'll notice that in order to find Chimes negligent, you have to find that they satisfied 3 elements. Now, these 3 elements, they line up with the 3 issues I told you about. First, it says the condition on the premises posed an unreasonable risk. It's your risk. The defendant knew or should have known that there was an unreasonable risk. That's your notice. And 3, the defendant failed to exercise ordinary care. So let's break those down. Let's talk about the hazards that were hiding in these shadows on January 23rd, 2019. Notice, risk, choices. Now, when it comes to notice, members of the jury, this is something that you need to take Ms. Deutsch and the defendants to task on because they told you today, they got up here in their opening statements and said this was 1 in 10,000. There was 99% chance this wouldn't have happened. This was a one-time thing. This was just unreasonable. Members of the jury, when a prior accident, the same nature, the same form, the same location, the same cause happens at your business 9 years prior to this one, that's not 1 in 1,000. It's not 1 in 10,000. Now that's notice. So let's take a look at those 2 incident reports. Let's take a look at the notice the defendants had. Because members of the jury, as you saw today, the defendants were on notice in 2010 when they filed their report. These are the defendants' employees' own words, not mine. Take their word for it. Because in 2010, they said that we should make sure there's adequate lighting on that loading dock. We should do that. That's what would prevent this from happening again. Unfortunately, it didn't prevent it. You see, this is the last page of the 2 reports, the one in 2010 and the one from Miss Gilmore's accident in 2019. The defendant had 9 years to resolve this issue, but let's look at how remarkably similar the recommendations were. Members of the jury, in both recommendations, And the one for today's case, they said, don't go outside without a light being turned on. Yeah, that's a bad idea. Oh, wait, our employees can't turn on the light. But we'll get to that in a second. So then let's go back to 2010. Make sure we have adequate lighting on the loading dock. That, members of the jury, is notice. That is notice that if they had taken the actions that they themselves said they should take, Miss Gilmore would not be sitting here today. It's notice. So let's turn to risk. Now, members of the jury, I want to be clear because, again, as we saw in all of the defendant's demonstratives, there's all this debate about who had ownership over the concrete and the guardrail and everything out back. I warned you that would happen today. There's a lot of debate there. But here's the key. Regardless of who had ownership over those features, the defendant certainly had control over and could have installed a light switch on their own premises. That has gone undisputed today. In fact, they stipulated to it. Members of the jury, that was in their control, and yet they ignored it. So why is the guardrail and the concrete relevant? Well, it's relevant because the defendant knew it existed. The defendant may not have been responsible for fixing it, but they knew it was out there, and they knew they did have the ability to turn on and install that simple light switch. Members of the jury, that's unreasonable risk. And I want to be very clear because they have spoken a lot today about how many times Miss Gilmore walked up and down those steps. They're right. She walked up and down those steps 10,000 times, up and then down, up and then down, because the defendant required her to do so. Because the defendant said, hey, if you're going to take a smoke break, you need to be out there. Oh, no, not only that, but if you need to take out the trash, which I require you to do 2 times a day, you have to be out there. It was the defendant that required Miss Gilmore to be out there that day. So when they try to blame Miss Gilmore's choices about stepping around the door in that windy, cold environment in the dark, keep in mind that the only reason she was out there was because they required her to be there. Oh, and they were the ones that requested that guardrail removed in the location they required their employees to be. So that brings us to the choices that the defendant made. Members of the jury, the defendant made many choices that showed that they failed to exercise reasonable care in today's case, but the most damning was the fact that they chose not to take their own recommendation. They chose not to install that light switch. One light switch that they absolutely could have installed at any point in time from 2010 when they told themselves they should do that to 2009 when Miss Gilmore injured herself. Members of the jury, the defendant chose not to take the choices, the reasonable measures they would have needed to take to protect Miss Gilmore that day. They chose not to install that light switch. That's why we ask you to hold them liable.
Okay. Ms. Doig, are you ready to proceed with closing argument?
Yes, Your Honor.
You may proceed.
One in 10,000. Those are the odds of the plaintiff getting injured by walking up and down those steps to take her smoke break. Odds so low, most people wouldn't take those stakes in Vegas or bet on sports. Members of the jury, those numbers told the Chimes department store that their loading dock was safe. Those numbers tell you there was no unreasonable risk of harm to Jordan Gilmore. Especially when you look at why this 1 in 10,000 times of going up and down those steps is different. It wasn't because of anything the Chimes family did or didn't do. It's because of the plaintiff's conduct herself. Members of the jury, this case, it's not about hazards hiding in the shadows. It's about numbers. And the numbers are clear that Chimes is not liable. Opposing counsel said something important in their closing and their opening today. I want you to remember when you go back to the deliberation room. Today, the plaintiff has the burden of proof to prove that Chimes department store was responsible. What that means is that they were the ones who had to come before you today and convince each and every one of you three things. First, that the condition of the loading area posed an unreasonable risk of harm. Second, that they knew or reasonably should have known of the danger. And third, that they failed to use ordinary care to protect Jordan Gilmore from the danger. Now, I want to focus on that first element, the one that the plaintiff failed to prove above all else, one that makes this case fairly simple for you. Whether the condition in question was an unreasonable risk of harm. It's not enough for the plaintiff to prove today, well, there could be a risk, there was a risk. It had to be an unreasonable one. Now, the plaintiff has tried to claim today that this loading dock that you saw was a dangerous area because there wasn't a light outside. Members of the jury, your job here today means that you don't just assume that this loading dock was dangerous, unreasonably dangerous, because the plaintiff fell. They had to prove that the risk of injuries on that dock, as you see it, was unreasonable. Plaintiff's testimony herself tells you that it wasn't. You see, the plaintiff had been working at this family store for 10 years. During those 10 years, she told you today, she went to the loading dock 20 times a week, 1,000 times a year, 10,000 times over the decade that she worked at Chimes. Not once during those 10,000 times did she fall. Not once did she slip. Not once did she ever get injured. Up and down that 2.5-foot stairwell every day for years. Members of the jury, if the plaintiff herself successfully went up and down these stairs 10,000 times without any harm, how can she expect you to believe it was an unreasonable risk? How could you possibly find Chimes responsible based on odds so low? Well, you can't, members of the jury, because that would be unreasonable. Opposing counsel has said over and over again today, there were hazards hiding in the shadows. But their own witness, the plaintiff herself, got up here today and she told you. She knew about everything. She knew about the stairs. She knew how many steps there were. She knew the distance of the stairs. She knew there was no guardrail. She knew there wasn't an outdoor light switch. She told you she knew that if she opened the door, she could provide light on the stairs. There is nothing hidden. Members of the jury, again, what you're here to decide is not whether or not there is a hazard hiding in the shadow. What you're here to decide is if the risk was unreasonable. And for the plaintiff, it was a 1 in 10,000 chance, but of all the employees, it's even more. Opposing counsel wants you to ignore math, ignore common sense, and say, well, because one person tripped 10 years before the plaintiff fell, and even though they weren't badly injured, well, this must be a death trap. Members of the jury, we know why that's not true. You've heard that for 15 years, employees have been traversing these stairs without guardrails. And there's something different about this time, plaintiff's time. Because the plaintiff was doing something that others wouldn't. Jungle gymming around the door while rushing up the stairs. Now, because the plaintiff failed to prove that first element to you, that there was an unreasonable risk of harm, ladies and gentlemen, you don't actually even need to go further with the verdict form. And you can find Chimes not liable. But the plaintiff wasn't done yet. Let's talk about the second thing that they needed to prove to you. Whether Chimes knew or reasonably should have known of the danger. Opposing counsel focused a lot today about a fall that happened 10 years ago. You heard that it was a little different. You heard that this was 10 years ago, that they were walking down the stairs and that they were carrying garbage, that they tripped. But the plaintiff, that's not how the plaintiff was injured. Opposing counsel talked about focusing on the choices in today's case, and I want to focus on the plaintiff's. Her choice to rush. You heard her admit to you on the stand that when she was done smoking her cigarette, she was in a hurry. She told you it was cold, it was windy, she wanted to go inside. She was fine when she was walking along, holding onto the wall. But when she realized her colleague was blocking the door, holding it open, she had a choice. She could say to her friend, hey, would you mind shutting the door? I'm going to come onto the platform. She could have had her friend open the door all the way. She could have had her friend go inside and she would wait her turn. She told you why she didn't. She was in a rush. So instead of widening up the platform for her to safely step forward, she tried to snake her way around the open door that was obvious to her. She knew the risk. She had a choice. She chose the wrong one. Which brings me to that third and final jury issue in today's case that the plaintiff also needed to show you. And that's that Chimes failed to exercise ordinary care, both by failing to warn Jordan Gilmore of the condition and failing to make the condition reasonably safe. Well, you know, members of the jury, that Miss Gilmore, she doesn't need a warning for a condition she knew about for 10 years. So let's focus on whether or not Chimes failed to make that condition safe. You met the owner of the Chimes department store, Reese Geller, today. He told you how this belonged to his grandparents and his parents, then him. He's dedicated his life to providing our community with goods and job opportunities. Now, you didn't get to meet the OSHA inspector today, Perry Hayden, but you did get to hear Mr. Hayden's deposition testimony today. You got to see his OSHA report, which was moved into evidence. When you go into the deliberation room, take a look at this report. Read it closely. Perry Hayden went to the Chimes department store only 6 months before the plaintiff's fall and did an inspection. Now, Mr. Hayden, he was an independent agent from the United States government. He wrote in this report, he didn't identify any potential workplace hazards inside the store. Even after going outside, inspecting the loading docks, walking down those same stairs that the plaintiff walked down, Perry Hayden gave no safety violation to Chime. Members of the jury, if anyone was to change the condition of the loading dock, it wasn't even Chimes to change. You heard today from Mr. Geller. He was a tenant. Family store, the Geller family, they didn't own the property where the plaintiff was injured. They were renters. You saw that lease today. You also saw a diagram of what, according to Mr. Geller, he was responsible for as the tenant and what his landlord, Kermit Realty, was responsible for. The loading dock in the back meant that Kermit Realty, not Chimes, was responsible for it. The area where the plaintiff fell. Which is why, if you're asked whether when you're asked whether the negligence, if any, of those named parties proximately caused the injury, you can answer no for Chimes department store, and yes for Kermit Realty Group and Jordan Gilmore. This is my last opportunity to speak with you. Because the plaintiff has the burden of proof in today's case, after I'm done speaking, they have one more chance to get up, try to persuade you. They do. Make sure that they answer the difficult questions in today's case that have been unanswered. Make them explain how a loading dock presented an unreasonable risk when Miss Gilmore walked up and down that stairwell 10,000 times without a single issue. Make them explain to you why Chimes and not the plaintiff should be responsible. The only thing different is that the plaintiff just didn't open the door. When these answers and explanations come, if they come at all, they don't persuade you, they don't ring true, tell the plaintiff that. Tell them that by finding Chimes department store not responsible. Thank you.
Okay, thank you, Ms. Doig. Ms. Nickel, do you have a rebuttal?
Yes, Your Honor, I do. And I believe Your Honor said 2 minutes, correct?
Correct.
Great. So I have a clock here, but if you need to, cut me off.
All right.
Make sure everything's good. Okay. Numbers. Members of the jury, what is the magic number of injuries that need to happen before Chimes department store installs a simple light switch? What is the number of injuries that need to occur that Chimes could have avoided before they do anything? It's not too, I don't know what that number is. You'd have to ask them. What we do know is that by my math, the odds of Mr. Gilmore being injured every time he walked up and down those steps went up each of those 10,000 times. Members of the jury, you're going to be presented with a jury form today. And on that form, you're going to be asked whether Chimes, Kermit, or Jordan were liable in today's case. Now, Chimes department store is the department store that failed to install that simple light switch, which they were capable of installing all along. They had notice that that was necessary from the prior injury. They knew it was dangerous and they failed to exercise ordinary care. We've resolved that. So let's talk just briefly about the points Ms. Deutsch raised on her closing. It's about Kermit and Jordan, but I want to be very clear. Kermit was not responsible and not in control of that area where that light switch was. Chimes was. Now, Jordan would never have been out there if he weren't required to be by his employer. So we ask that you fill that in now. When asked to assign liability, the only verdict that aligns with justice today is to assign 100% of the fault to the corporation who turned Mr. Gilmore's safety into a numbers game. Find the defendant liable.
Okay, thank you, Ms. Nickel. That concludes our closing arguments, and the case is now considered submitted to the jury. Jury, please fill out your ballots and submit them to the ballot room via email, and let us know when you've done that. As you complete your ballots, I'll have you each give some brief comments to the competitors so that they can improve their game going forward. I guess while they're doing that, I'll start. Great job, guys. Good job. You both made it clear why you're here. You're the top and the best of the nation and the competitors in mock trial, so you can be proud of that. Very briefly, I will try to give you each something to move forward with, and take this in the nature it's given, because I am not as familiar by a long shot with the specifics of the case packet and the evidence. Y'all know much more about that than I do. But what I will say is this: it seems like there's a lot of paths to victory for both sides here. And I think it's a mistake to narrow your focus too much on what was wrong or what was right about this platform and loading dock. On the plaintiff side, I think it's a mistake to focus solely on the light, even though that's a good thing to focus on. I think there's a number of different ways that this could have been dangerous. And likewise from the defense side, I think you do yourself a disservice if you focus solely on the number of times the plaintiff used the stair without an incident. I think that's something to point out. I think it's a good thing to point out. But just because she used it 10,000 times without an accident doesn't mean that odds of injury are 1 in 10,000. And so I heard you at the end going harder on comparative fault. I would have come out from the beginning going after comparative fault more strongly in a respectful way. So those are my 2 small comments for you both. That said, it was tremendous and you can both be very proud. So it looks like we have at least 2 of our jurors done. Mr. Alexander, I think you were first to come on the screen. Do you want to give some comments for us?
Of course. First, let me also congratulate both of you all. I think I probably speak for everybody. I would be proud to practice with you and to try a case with either one of you. You're tremendous. Ms. Nickel, be very, very careful what you promise and how you frame your case on opening statement, because I thought it was going to be like we were in a tunnel. And so if you overpromise, sometimes you can't live up to that promise. And then when I hear that they'd been out in the dark before, I don't know. The other thing is if dark is going to be your theme, make sure your client, and your client may have said this, but if she did, I didn't hear it. Make sure your client said the only reason this happened is because I couldn't see. Ms. Doig, I thought you did a good job using words like Spider-Man. I don't know if that was in the deposition, but you Spider-Maned around the door. That was great because obviously contrib is what you're going for. Also, both of you all, if you're going to have depositions, and I don't know if those are the only 4 witnesses you've been given at this point, okay? If you're going to use depositions, which is great, ask the court to tell the jury what a deposition is. That it's the same exact thing as the people that you just saw in front of you, so that if you're reading stuff that helps you, you want the jury to know that this isn't just lawyers reading. This was a witness who really testified, and it was under oath, and it was sworn to, that sort of thing. The only other thing, I sort of disagree. I disagree with the judge on this. I liked the 10,000 times. I thought that was great. I would have gone even farther, to be honest with you, and said, but that's 1 employee. So we have 2 accidents. There are 50 employees who work at the store. Over 10 years, there have been 2 accidents and only one of them has been serious. That's unreasonable. I don't think so. But anyway, great job.
Okay, Mr. Steed.
Yes, I'll try to be real quick. I echo what both of them said. And by the way, Mr. Alexander kicked me in mock trial when I was at Baylor 38 years ago. So him saying he would partner with you ought to be encouraging to you. You both did a great job. The point of all this is, you're really good or you wouldn't be here. It's to learn little tidbits to help you even be better in your next competition. So I'm going to be brief. 2 things. Whether you've done it 38 years or 38 days, the hardest thing in trial is to listen to what the witness says or the other lawyer says and use it to make them wish that they had never said it. Not ramming it down their throat, doing it gently and kindly, but effectively. Okay, so I'm gonna give you 2 examples. Number 1, visually and audio-wise. I agree with Joe on the darkness, but you got to be really careful with visuals, because I don't know what the judge and the other jurors thought, but when you put that photo up, Ms. Nickel, at the beginning, and then you went dim with it, I know the effect you were intending, but I looked at it and I said, you can still see. I mean, you can see that concrete. I'd either black it out for impact and then have your lady come up and do what Joe said, or I wouldn't do it, because if you can see that concrete and see that door, the jury is going to think she could have seen it, all right? And she could have just waited and said, open the door or whatever. So, but also listen, because Ms. Doig said on opening that the defendant did everything they were supposed to do. And you did a good job of pointing out, no, the light switch. And I think that's a good focal point for you, because all the other things kind of tend to go towards contrib. So I like the focus on the light, but I would make it this. In the lease agreement, they're to be responsible for the safety inside. And there was this distinguishing by Ms. Dwight about what's in and out. But once the owner said we're responsible for safety inside, what's more important safety-wise on the inside than the human beings? The customers and the employees. And if safety is really big on the inside for those that you should care most about, pay for the dang light switch and get it working. You see my point? So try to listen for those little subtleties that you can then capture on, because if they say it and you use it against them, the jury remembers it. All right. Also, I think Ms. Joy did a great job, by the way, both of you, but I think you missed a good chance to cross the plaintiff gently but firmly when on redirect, she was asked, so why did you have the door open? Because you were doing the Spider-Man and all that and been effective with that. So to rebut that, Ms. Nickel asked her, why'd you leave the door open? Do you remember her answer? What the plaintiff said? It was to keep the light on so I could see better. Well, she knew then there's a risk, and that goes into your contrib from her own mouth. So anyway, that's too many comments probably, but y'all were great. But if you use any of that going forward, good luck in your other rounds.
Okay, Ms. Sheridan.
Thank you, Judge, and good to see you, by the way. You are both brilliant. You made my heart happy today. As the only woman juror on this panel, you literally made me happy today. And I, as a Baylor lawyer and a former national mock trial team on behalf of Baylor that won the national championship, I am not an easy person to impress. And I literally have almost nothing to say to you other than you are both brilliant and you make me happy for the future of our law and for women. I am just thrilled for both of you. I appreciated both of your, so one of my things is demeanor and professionalism. That at the end of the day, you can be incompetent, you can be not a very good lawyer, but as long as you're ethical and you're honest and you're kind, that takes me to the end of the day. And you're both wonderfully competent, but you were also very kind and professional, and to be your age and already be that wise about how to treat each other and how to treat the case without being overly aggressive, but also being direct and doing what you need to do. That just tells me that you have worlds of wisdom with you. And that's really all I have to say, other than I would be a little more careful, I think, in our Zoom culture, and hopefully it won't last much longer, but in our Zoom culture, facial expressions and responses may be a little more observant than they might normally be. So be very cognizant of that. I don't have the best poker face in the world, and I'll be the first one to admit that, but a happy poker face is better than a irritated poker face. So just be a little aware of that. But all I could think of from both of you giving your first opening statements, all I could think of is that I was happy for the future of our law. So I am, I know I'm not your mothers, but I'm proud of you both, and I wish you both well. It was really lovely to watch you both. You were you made my heart happy. So there's that.
Thank you, Ms. Sheridan. Mr. Jones?
Okay, so I'm last, I think. Lauren and Rebecca, when I was competing, I never remembered what the last judge's comments said, so I'll try to be really brief. Three things. First, don't use unnecessary objections. Both of you did this. You objected when you got frustrated. And both times that you objected on both sides, it was unnecessary. I think somebody did a leading objection and somebody did a counsel testifying objection. Both objections were early in the testimony, and it was something that I would have just let go, and that it kind of makes you look a little petty. If you do that in competition, it makes you look a little bit like, well, I'm just frustrated at the way this is going. And so you could have saved your objection to something, a little bit more, after the fifth leading question or the fourth leading question or something like that. The plaintiff's theme, or excuse me, the defense theme. You said a few times, Lauren, that the plaintiff was unlucky. I think that that's not the way you should say it, because your whole argument is contributory negligence. So it's not unlucky, it's irresponsible. She walked up the stairs in a way that no one else did. And so it's not unlucky, it's irresponsible. And so it makes it unique. On the plaintiff's side, you said something in your rebuttal and closing that I loved, and I didn't hear a whole lot of, and that was, how many accidents does it take before they do something so simple? And that is something that should have come out in your opening. It shouldn't have been, you keep the theme, but I mean, that should be something that you say over and over and over again. This is so easy. How many people have to get hurt before you do something that you admit is so easy? And so you said that in the last little bit, and it clicked for me that I was like, oh my gosh, it's just a light switch. How hard is that? It's so easy for you to fix. So that's all I have. Those are my three comments.
Thank you all very, very much.
Thank you for those comments, guys. Before I let anyone go, let me just check with the tab room and make sure they've all received your ballots, okay?
Thank you all so much for judging and your feedback. It really meant a lot.
Thank you
And
for
great
all
job,
your-
Rebecca, as always.
You too, Lauren. It was great to see you again. It's
You
always a
too.
pleasure.
Thank you for all your hard work. It was great. I know this is not an easy competition.
Truly, y'all are like spectacular. Very proud of you.
It's quite the compliment. We'll take the high praise.
Are you guys?
Not a lot of it in this form.
What year are you guys?
I'm a 3L, I believe.
Me too.
Yeah.
Nice.
All right, guys, the tab room says we're good to go, so the judges can be excused. And for the competitors, good luck in the future of the tournament, and go get some sleep, hopefully, okay?
Thank you.
very much.
Have a great
Thanks, everybody.
day.
Joel, great
Best of
seeing you,
luck to
man.
you.
Great to see you too, Judge. Good to see you.
And I don't think I
Bye-bye.
really did kick your butt, but it's a great story.
Thank y'all.
Bye.
Bye.